Similar.
Yes.
But item 12, my lord, I am for the respondent, my lord.
It's a
Item
matter
12.
where there is a direction very
Yes.
Yeah.
Item 12, my lord, I pray, my lord, next week is short adjournment for the respondents.
You want adjournment?
Yes, my lord, item 12 for the respondent and for the respondent. With short adjournment.
Which year?
WPC number 8175 of 2025.
All right.
It's okay.
2 weeks?
My lord, 2 weeks.
I am for the petitioner.
You're for the petitioner. Any other? He wants time.
In regulation service, last day also they took time.
Regulation will do that. We coordinate at the request of the.
Next to the slide.
Oh, please, my lord.
Should I start?
Yes.
Nice. No.
It will take some time.
I will try to make it as brief as possible.
No problem.
No, I'll not take time.
No. I was just telling your friends can go for a coffee round and come back. You can argue.
State has not filed any counter as yet.
We don't.
His allegations are against the state. And
But there is a direction by the apex court.
Yes.
Dispose of this matter on work week. I think date period is also prescribed.
Yes.
the period is prescribed.
Yes, prescribed.
I've said
Can
that.
I pray that Lordship may call this matter up next week so that coming
No,
week?
next week time will be over.
But the reply is already there. I will be referring to
it is
that.
a preliminary counter. It is not there. Now,
But
none of
nothing
the
addressed.
So
that
my knowledge, my lords, I am for opposite part number 12 and 12 contesting of
The apex court, they should be amendment.
That one.
Do you have a copy of that apex court order?
Yes.
Do that.
That's what I was reading. This is this. Can I just start with that order? I have put one copy.
You read it.
I read it.
We are accustomed to that.
I'm so sorry.
No problem.
I'm so sorry, Milord Sam. I don't realize that would be required. Learned counsel appearing for respondent number 8 to 16, 6. That's on behalf of the government. On the ground that learned advocate on record is hospitalized, we are informed that the High Court has not taken up the matter for consideration despite the orders dated 15th April 2025, 8th August 2025 passed by this court. In fact, by the way of latter order dated 8th August 2025, we had requested the High Court to hear the petition or the applications filed therein on merits and in accordance with law, instead of awaiting the result of the present special petitions. As the matter pertains to insolvency and bankruptcy code 2000 proceedings thereunder are statutorily time-barred, it would be necessary for the High Court to give priority to the pending writ petition and dispose of the same as expeditiously as possible. As that has not happened despite our earlier requests, the Registrar of the High Court shall place the matter before the Honorable Chief Justice of the Honorable High Court of Orissa, Cuttack, for passing appropriate orders for listing the matter forthwith to enable its disposal at the earliest. Release this matter on 17th of February. So that's the context in which I have come.
17th of April.
February. This coming 17th.
Yeah.
Not April. So now I would start my submission with an order of this Honorable Court, and that is 19th February 2025, because that would delineate the issue and contour of the whole case. Can I take your Lordship's attention to 19th February 2025?
That will take. Can you make a statement of foundational facts?
That's what this will be coming here. Yes. That will actually consult the whole issue.
Okay.
That's what I understand.
You are Mr. Bahali.
I am Bhapatra. My associate friend is Mr. Bahali. Can I start now?
Yes, sir.
Yes, nerds. Mr. Bahali, he was the one who first addressed this Honorable Court. Mr. Bahali, learned advocate, appears on behalf of the petitioners and submits prayer of his client for issuance of orders to pass memorandum of understanding dated 20th April 1991 and sale deed dated 5th January 1994. He submits government land was dealt with for purpose of industry and the purpose has long since been lost. He refers to preliminary counter filed by the collector and district magistrate, drawing attention to paragraphs 7 to 9. He submits preservation of the government land has been flagged. Further information emanates that opposite party number 10
to 13.
Yes, have applied for mutation and change of category from Patadar to Sthitiban for carving out the land into plot for sale.
1 second. What is meant by Patadar and what is meant by Stitiban?
Millard, there are two sets of rights, tenants. One is leasehold and one is freehold. One is leasehold right is not a permanent one.
The property belonging to the government.
Yes.
He
yes.
is only the fee simple. He is holder of the fee simple.
Yes.
Okay.
Leasehold, and once it is freehold, then ownership.
He becomes the owner.
Yes.
Okay.
So leasehold period and
Stitiban.
is a freehold land.
Freehold.
Freehold land. For carving out the land into plot for sale. It is not for public purpose of setting up industry. He seeks intervention. Mr. Patnaik, learned advocate, additional government advocate, appears on behalf of the state and submits. Mutation has not happened. Matter is with the law department. Decision to be taken and instructions issued are awaited. See praise for an adjournment. Mr. Acharya, learned advocate, appears on behalf of the opposite party number 10 and 13, 10 to 13.
Please do not read names of the lawyers.
Ballarpur Industries was subjected to insolvency proceedings. A resolution plan has been approved. Plan took into consideration the company's interest in the land. As such, it is entitled to have mutation and change of category so that it can be dealt with. His client, being successful resolution applicant, had on that basis applied. State is to respond on petitioner's contention that alienation for purpose of industry and purpose lost would thereby render basis for this alienation removed. State is of submissions made by opposite party number 10 to 13. Said opposite parties will be hard on their rights to deal with the land for a different purpose. State and opposite party number 10 to 13 may file their respective affidavits on adjourned date on copies of the petitioners. List on 19th March 2025 as prayed for by Mrs. Patnaik, status quo be maintained till next date of hearing. Now, statement, 2 lines I would submit. There were earlier a paper industry called Titagarh paper mills. That faced insolvency proceedings.
This industry was established on the government land.
Yes. I'll be coming to that in certain 2 lines I'll be sharing, then I'll be coming to those facts. Not I'll only deal with 3.
Partly government land, partly private land.
I'll come to that. I'm coming to that. So Titagarh paper mill became sick. Then Ballarpur industry took over. Now, once Ballarpur industry took over, the question
taken under BIF.
Yes. I'll be coming to that. Only just 2 lines I'm making, then I'll be coming to the point. Now, the question arises that there was an MOU with the Ballarpur industries. And that MOU says...
MOU between?
Government and Ballarpur industry. And MOU says
that... Can you just give me the date?
I'll be coming to that. Okay. Just one by one, I'll be coming. Just now, I'll be coming.
I've put a date chart.
No,
was for my purpose.
Okay.
I think it may be helpful.
It will help. Fine.
Yeah.
I'm straight away.
Eat the place to him so that he can stand properly. No?
I'll straight away.
This side.
I'll straight away show the documents. What I'm emphasizing here is that when a leasehold property is to be transferred from one industry to another industry, then what is transferred is only the leasehold properties. It is not sold. That's the primary argument.
Private, but limited interest lease is defined.
Absolutely.
I think under 103 and 196 of the transfer of property. It says transfer of interest because it is one of the traditional 5 modes of...
Absolutely. 105 of Transfer of Property Act.
Transfer of the right to enjoy the property.
Absolutely. So there is a distinction between 54 and 105.
Correct.
Absolutely.
54 absolute transfer.
Absolutely. I'm with you. Now, what is this particular order by this Honorable Court was under challenge before the Honorable Supreme Court.
This order?
Yes. This status quo order, this interlocutory order is under challenge before the Honorable Supreme Court. Now, Honorable Supreme Court passed an order.
One second. Can you make gist of this order? What this order says?
This particular order, that one I read. 2 things. That Ballarpur Industries wanted to sell properties because it is undergoing insolvency, so it wants to sell off and pay the debt in Delhi to other debt creditors. Our view is Ballarpur Industries, though there is a sale deed executed on behalf of the government, but it is contrary to MOU because execution of sale deed follows from the MOU. So therefore, if that happens, then there is an injury to the public exchequer. And that is what is the subject matter of this PI.
Who are you?
So I am for the PI.
Mr. PIL.
Yes. Now, kindly see the order dated.
Slowly. One second.
Yes, I'm so sorry.
Once you say PIL, it goes from BL Vadera to Puninaha.
Absolutely.
Just I want to see where you will sit. Fit into that concept.
Okay, in that event, perhaps it could have been beneficial for me had I have brought that SP Gupta judgment, wherein it is demonstrably showing that the public injury is apparent. The moment I explain to your lordship that there is a clear public injury, the locus thing goes back. That I can show to your lordship for me. SP.
After SP Gupta,
Yes.
lot of jurisprudence.
That's the foundation.
That's only the first judge's case.
Yes, judge's case. Yes. I mean, I'm sharing from my memory because your lordship put it question. And I'm sure it is right. I can show that. Now, can I take your lordship's attention to the order dated 9th May 2025? It should be in the paper book.
You have not completed your narration as to what this order is saying.
Okay, I'm so sorry. I thought I did. My submission was that in that interlocutory order, there are two things. That the Ballarpur Industries wanted those properties, which it claimed to have bought from Odisha government. We submitted that actually there are two documents. One is MOU, pursuant to which all transaction takes place. Pursuant to which, yes, transfer of property took place. MOU does not contemplate any sale. So therefore, it could all actually have been transferred and not sold, which is what is vindicated in the collector's letter to the government.
In other words, the BIFR agency will get lease, not sale, subject matter of crux of this matter.
Crux of the case is this. But that's what I explained. Now, what happened when they went to the Supreme Court? Now, when the matter went to the Supreme Court, they said that a resolution plan is already approved. So therefore, the Honorable High Court could not have entertained a writ petition. So
in other words, even if it is a sale, even if there is a hurt to the interest of the proprietorial interest of the state, still nothing can be done. We should keep quiet is their version. That's
their version. They say the High Court doesn't have any jurisdiction anymore. The moment resolution plan is approved and he says you go and sell. Now, the Honorable Supreme Court issued only notice on this purpose, saying that the Honorable High Court could not have entertained a writ petition. So therefore, my submission today should begin with, in all fairness, that whether the writ petition should be entertained or not.
On locus.
Particularly when...
Any other, apart from locus, that which jurisdiction, are there any complicated issues of facts which need...
No. Because the only limited question, in fact, I was ready to argue before the Honorable Supreme Court only a limited ground, whether the Honorable High Court could have entertained the writ petition or not. When I started it, I said, well, we are waiting for the order from the Honorable High Court. You better go and argue it before the Honorable High Court.
Therefore, even if matter is pending before us, you go and argue the matter before the High Court.
That's it.
That's all your feedback.
That's right.
Yeah.
So therefore,
in other two things will arise. Number one, your locus and locum. Number two, once resolution professional does the exercise.
This is intertwined. These 2 points will be coming together.
Intertwined there.
These 2 points will be coming together in my course of submission when I claim that this Honorable High Court has read jurisdiction actually. That's my point. So to this extent, can I take your Lordship's attention to a judgment of 3-judge bench of the Honorable Supreme Court in Embassy Judgment Development Private Limited? I just pass it on 2 words.
2 copies you have?
Yeah, I have 3 copies. One is for my learned colleague on the other side also. Can I pass it on?
Anybody challenges the locus and locum? You want to challenge the locus of the petition?
Yeah, so we are opposite part of
Sir, can we go a little methodically?
Yes, sir.
The first issue has to the maintainability, locus stand.
Yes, I'm exactly on that point.
Locus stand.
I'm exactly on that point. Absolutely. It's my-
Maintainability on account of your locus stand.
Yes, yes. I'm
That's
exactly on that point.
Do you have anything more to say on that?
And
You have said that. What do you want to say?
two judgments I'm showing.
What they say?
Yes. One, when the proceedings under the insolvency and bankruptcy code started, whether the writ could be entertained or not.
Writ could be entertained. It
But-
always can be entertained.
No, on the question.
Subject to 3 exceptions which the apex court in the latest decision has said. Whether writ can be entertained at the instance of a person who is not, has nothing to do with the IBC proceedings.
Absolutely. So it has to be in relation to.
In relation.
So this the latest judgment in this case is only I think last week or so. This our judgment. This I will be coming to. Only 2 judgments I will be showing. That lordship will suffice. I'm so happy. Will let's kindly have para 2 of this judgment.
There are 2 of the judgment.
Beginning. Next page. Next page. Okay. Can I read, my lords? Whether the High Court ought to interfere under Article 226, 227 of the Constitution with an order passed by the NC.
Which page you are reading?
Para 2, beginning, judgment beginning.
Beginning what?
Second page. It should be page number 3. Yes, please.
3.
Yes, please. Whether the High Court ought to interfere under Article 226, 227 of the Constitution with an order passed by the NCLT in a proceeding under Insolvency and Bankruptcy Code 2016, ignoring the availability of statutory remedy of appeal to the NCLT, and if so, under what circumstances? Your Lordship has already answered to question before I could discuss, but the conclusion is para 52.
The second question will not arise.
Millets?
The second question which they have framed in para 2.
Yes, that will also.
right?
That will also. That
They
will
have
also.
taken up pleadings for that.
Yes, we have taken.
About fraud, fabrication, etc.
No, fraud I have not taken.
Then so you will not travel to second question at all.
I'm not going into that. I'm not going into that. But then that would ultimately come in.
No, that will not.
That would ultimately come in. So, because we are talking about transfer. So
Legal transfer is one thing.
yeah, that's
Fraudulent
very
is
fair,
another.
very fair, very fair.
Now, where is the answer to this question?
52.
Conclusion.
Yes,
52.
52. It has to be read in total. Only one paragraph I'll be reading. The upshot of the above question is that NCLT and NCLAT would have jurisdiction to inquire into question of fraud. They would not have jurisdiction to adjudicate upon disputes such as those arising under MMDR Act 1957 and rules issued 52. Last page. To adjudicate upon disputes such as those arising under MMDR Act 1957 and rules issued thereunder, especially when disputes revolve around.
Therefore, they say High Court has jurisdiction.
Yes.
Understood. What's
So
the next point?
my question is that it has to be in relation to proceedings or arising out of the proceedings under the NCLT Act. So this is also Miller's.
Appearing for the PIL petitioner submits that writ petition of the county is maintainable in PIL jurisdiction. In view of petition of apex court in Embassy Property Developments Private Limited versus State of Karnataka, paragraph 51, 52. But this was not a PIL.
That was,
It was not. Embassy property.
No, this is not a PIL, it seems.
Yeah.
No.
Now, what's your answer?
It's not. No, I am coming to the basic issue with regard to the jurisdiction. The question is whether, when a matter NCLT is to deal with, whether it ousts the jurisdiction of the Honorable
No
High Court.
question of ousting.
Now, as regards my locus, I had started at the beginning by naming SP Gupta's case that
When asked as to whether this decision arose in a case fitting into PIL jurisdiction, counsel in all fairness submits, it did not. First, see, court has got jurisdiction in something is one thing. You were coming to court and knocking at its door. Whether that is permissible or not is the question before us.
that's right. That is the reason why I was saying at the beginning.
Give that. What is your...
That's what I'm saying. That's what at the beginning I said. Perhaps I could have got that SP Gupta judgment.
No, not
No, the reason is the public injury is apparent.
Yes.
The injury that government selling out 581 acres of land in 6 crore rupees to a private company is causing injury to the public and to the government exchequer.
Who are you?
I'm a public. I'm an employee. I was a farmer.
You may be in Katak market. That will not give you the... You may be a member of public. That will not give you the locus. How? What are your credentials?
I have no...
Show that in your petition. You can't argue that. You have to vary what you are stating.
Para 4 of my petition I need.
Read.
It is pertinent to mention that the petitioners have no personal interest in the present matter and are bona fide belief that the present matter.
Many petitioner.
There are 6 petitioners.
Each one of them, what they do?
They are having land adjacent and
Show that.
example.
They were actually ex-employees of Titagarh paper mill.
They are ex-employees.
Yes.
Where have you stated?
Para 4 and 5, I these two paragraphs I read. Can I read now? Para 4. Petitioners.
No, I read it. We have read it. Where is that sentence that the members, they were the ex-employees of the organization?
I read it somewhere.
On what basis you say
Yes, ma'am.
there are ex-employees of the organization? It should arise. You can't put your personal knowledge into the proceeding.
No.
You should arise it from the pleadings of the parties.
Yes. I think
Where is it?
there was a representation there. Your Lordship, can have a look at page 58. That's a document.
This is by whom? Who are the signatories to this document?
There are so many signatories of the village.
No, others we are not concerned.
Petitioners are signatories to this.
Whether their names appear here?
Yeah.
Petitioner's figure?
Yes. So all I can all of them.
But your statement that they are ex-employees of so-and-so, so-and-so.
That's what I'm saying. Page 58 for have a look.
Which line?
Page 58, first line.
Ex-employees of
Yes.
Petitioner claim to be ex-employees of the erstwhile DPM. Which factor is stated in their representation dated 26th May 2022 at an exact spot. although it is not mentioned petition. It is not averred in the petition.
No, I somehow am missing it. I think it is somewhere in the petition. I'll just have a look. I'll ask my
There are people who are briefing counsel to point out that sentence in the petition.
I'll ask.
So that will rectify
I will.
our petition. Yes.
Yes, members. Now, I was at the basic question that your lordship raised is with regard to as your lordship rightly said, when a matter is entertained by NCLT, resolution plan is passed, whether it takes away the jurisdiction of the Honorable Court. That answer I wanted to give, that this Honorable Court
of expert and answer.
That's right. And this is subsequent judgment, and it says,
one judgment is sufficient.
okay, fine.
I mean, Article 141 says,
Yes.
law declared by the apex.
That has not been
It does not
upheld.
say.
That's consistent.
It does not say law repeatedly declared by the apex court.
I'm so obliged.
Therefore, you can say your time, you can say our time.
I'm so
Both.
obliged.
Yeah.
I'm so obliged. But for the sake of convenience, if your lordship wants to take cognizance of it, you can. Now I come to,
Who are the other signatories to the representation?
they're all localites,
The
villagers,
said
and
representation is signed by
residing in that adjacent areas.
villagers residing in the area appertinent to TPM.
Absolutely.
Have you given their names there?
In the representation, it is there, but in the petition, there are only 6.
In the representation, where are the names? Only signatures are.
No, all the names are not reflected in the petition.
Yes,
Out of these petitioners, the representation, those who are signed, 7 of them have come to the Honorable High Court in the form of a PIL.
Out of several such villagers, 7 are petitioning. First one. What? Next one.
Now, if your lordship would permit me,
No.
hence I would come to the
One
imbue.
second. You, at para 4, said petitioners do not have any personal interest.
Absolutely.
If they do not have any personal interest, why they are mentioning that they are ex-employees of the PTM or something like that?
Absolutely.
Yes.
This answer is only to this extent that they are aware of the developments happening in and around that land. When the land is being sold, they are getting information. They are emotionally connected. They feel that if it continues or some industry continues in future, maybe their next generation would be getting employment or the people of that area would benefit at large. So it cannot be said they are personally interested. The only thing is they are privy to information that coming time and again from the revenue authorities that it is likely to be sold. Now, that's right. Now that will come. Now, can I take your lordship's attention to the MOU?
Whether petitioners had filed any other petition, etc., at any point of time.
Earlier, there was a petition.
That filed?
Yes.
They
Earlier,
filed, 2 set of petitions. One is PI 2020, by one with trademarks and positive in Annex 3. There, Honorable High Court in Division Bench directed any person interested, go and approach before the NCLT.
Go and approach
NCLT.
NCLT.
That is the order management on a friend deposited in Annex 3.
that I'm coming. That no issue. That's it.
Add to that also, there is another writ petition. Their counter was filed by the self-same person, but he couldn't pursue it, it was dismissed for default.
Petition.
We are dismissed in default.
Then before my intervene in my lord's submission, my friend's submission, may I point out one thing. My learned friend has pointed out that resolution, that application. I compared it. Excepting one, the signature of other petitioners are not there.
No, should be there. He is saying only except one, other signatories are not there.
That is there, my lords can check it.
When it was happened. Later.
Excepting opposite party numbers, petition number 6. I don't find it.
No, I'll check it. I'll check it. I'll find it. I think.
No, you have to answer it right now.
Right. I'm so sorry, madam.
Have you taken up that contention in your counter, in your
Is that there no more?
in your counter?
You know what I mean? In our counter, we have
I'm asking you. If question will admit binary answers,
but
yes or no,
No.
nothing more.
that is not there.
Then you can explain.
That is not.
They have not taken up that contention.
Actions has come in a PIL. We said they don't have a locus. On two grounds, point of view.
Suppose if a land given to you on lease is sold as if, then it is 500 odd acres of land. How many acres of
581 acres.
581 acres land? It is given only on lease basis.
Not all men,
Huh?
not total,
Not true.
part of them.
It is given by not lease
No,
basis.
private lands are there.
No, how many? All right. What are the lands given on lease to you?
But I got that.
At
And
least 333 acres leasehold.
that is there minus in the VIFR minus the MOU that has been stated.
That's all. We are only lessee. You are not
No, man,
buyer.
I will explain that minus. Let my lawyer friend come from it, I will explain.
And when by this arrangement, if other person becomes the owner, that will be hurting the interest, the proprietorial interest of the state is his version. BL Vadera.
I will say it.
So now in MOU, that relevant portion which your lordship is just putting a query, in page 74, this is PDF 74, what should be running page? MOU, page 30. Page 30.
This,
MOU
how many acres of land on lease?
That's 581, that's what I'm reading. Kindly have a look at that.
No, not like that. You should show under which instrument lease has been granted. That you have to say.
I'm reading that. I'm exactly reading that. That is page number 30. At
30.
yes. Can I read now? Last para, and whereas the MOU provides.
And where MOU provides.
Yes. Hereunder, the terms and conditions regulating the transfer of the assets and liabilities of TPM3, including the lands in its
So
possession.
3.34 acres is government land. As my
And-
brother pointed out.
And 240.
That is private land which they have bought.
No. I don't think they have bought
200
it.
some
Because
odd they have purchased.
who purchased it?
200
Yeah,
some
yeah.
odd they have purchased.
Private acquired land.
This is
They
the
have
government.
stated there.
Kindly let's read it further. Let's read it further. I think there's
How long you can go on arguing like
my lord, one paragraph, only one paragraph I'll be reading here. And in my understanding, it's entire 581 acres.
where have you stated?
That's what I'm saying. Kindly have a look.
This is
The MOU. This is-
MOU.
Yeah, this is the MOU, page 30.
no, it says only
Let's read
33.34
only
acres.
one
of land.
paragraph. Only one paragraph. Let's read it further, my lords. I'm reading. Let's read further. 586 acres Chaudhar, comprising 333 acres of government land and 247 acres of private
Private.
acquired land.
Private acquired land. means,
It doesn't mean that it is BILT. They'll have to explain. I will read it further. It would show that it is government land now. And
There, I will read it completely.
now, if I read it further, if your lordship read next page, and temporary renewable government lease land at the above mentioned areas.
Above mentioned one sentence you can't read
No,
like a
that's what-
postcard letter.
No, that's
It is
right.
a-
This-
yeah, no, sir. Do not waste our time.
Yes, sir.
We are telling you.
Yes, ma'am.
It is 333.33 acres is leasehold land. Rest of the land is private land. Even on 3 is another. You can't go on arguing endlessly.
No,
We
no,
don't
no.
permit that.
I have no-
We have to ration our time here.
Absolutely.
Your friends are waiting.
Absolutely. I have no intention on that.
Just go to next point.
Yes, madam.
Leave it now.
Right.
We have understood.
No.
The land that is dispute in this area belongs to 333.34 acres of government land allotted to, what is that, PT? What is that? Industrial? PTM. PTM. Which aspect is gathered from the MOU dated 20 April 1991 between the company and the government, a copy whereof avails at Annexure 1. Yeah.
Yes, sir.
Next one.
I was showing me that. In fact, they have filed a counter in the Supreme Court saying that this is 581 acres of land.
That's not done for us.
That's fine. That's fine. Now,
Next.
I would take your attention to the annexure that is sale deed.
The company gave under BIF for sale deed.
That's right, sale deed.
Sale deed dated?
This is annexure 2. This is at page number 3940. That should be 40. 40.
Yes, we got that sale deed. Annexure 2.
That's right.
Dated 5 January 1994.
That's right. Kindly see.
Let us go to the schedule to the
41, page 41, next para, next page. And whereas third paragraph, second paragraph onwards, only 2 paragraphs I'll be reading, not much. And whereas as per the aforesaid scheme, a finalized mill number 3 TFM.
They say they project themselves to the absolute owners of entire this property. That is wrong, is your worship.
Is my
Therefore, intervention of the court is called.
Absolutely. That's my submission.
The counsel points out the sale deed dated 5/1/1994 at Annexure 2,
Yes, ma'am.
which is structured on a premise that the seller happens to be the absolute owner of entire land, namely 500 and how many acres?
81 acres.
581 acres. When out of that 333 plus land happens to be a leasehold granted by the government. Yes.
Just correction, my lord. Next step 2. My lord, the deal. My lord, deal with it. My lord, it is not 500 some acre. It is total for 621.690.
Duplicate 600 order. Yes.
621.
This question is simple. At least 333 acres is a leasehold land. How could you sell that property as projecting yourself to be owner of that entire land?
But who sold me? Government is sold.
So where the government has sold?
But that is the
He
deal.
says this now the government is the who is the executant of this?
The government.
Government.
Government has given on seal. Government sold it in our favor. Even in a on present on chairmanship of the chief minister, then all collectors, everybody appeared there. Thereafter, decided
For 333 acres, what is the consideration paid?
in total manners they have taken.
How much?
Then manners it was 12 crores.
No, that was 600 odd acres of
Yes,
land.
ma'am. Yes.
No, this out of that 333,
Yes.
about more than it is about 50% of the land.
50%.
What is the rate outside in the market?
Normal. What we can say, my lords, but fact remains.
No, we are asking. We do not. If you know, say no. If you don't say no, we know how to get that information.
I think I don't have a specific.
But this was in the year 1990.
92.
90.
Yes, ma'am. That is exactly I want to point out, ma'am.
1992, the sale price was only 6
94. 94.
The
Sale price was 6 crore. Other includes other charges, electricity and all that.
The MOU is
only
90. MOU is 91, 20th April 91. The sale deed
is 94.
94, 5th January 94. Absolutely.
Yeah, at that time, they were in employment, your clients.
Because BIFR was no, they were
But
not.
this LD took place in 1994.
Absolutely, that's
In
what.
which you are challenging it.
No, we challenge it because there are a number of litigations, as my learned friend pointed out. We only came to know that it is actually sold. And the collector says, yes, we agree that there is something wrong in the transfer of this property from government to BILT.
How the collector will say?
That's
Government is above collector.
That's what I'm pointing out. That is how the Honorable Court
It
said.
is not. Collector cannot sit over the judgment of the government. Government is a collector is only a person or designate.
So that is the reason why I was reading the very first order, wherein the Honorable
Kindly go to your prayer.
Yes,
Prayer in the petition.
yes,
If it is 1994,
yes.
how can we turn the clock back and run into the
But there is a continued cause of action that I can demonstrate.
what continued further?
Because there are 2-3 litigations earlier there.
First litigation began when?
In this case,
Tell them. If first litigation
Yes.
is within the period of then
No.
there is scope for your argument.
no, I can show the previous litigations from which all the sequence continued, and that is annexure. Your Lordship could have a look at page 65.
Earlier litigation means not some litigation, any litigation, every litigation. Litigation where it has something to do with the title to the land, only such litigation.
Yes,
The
yes.
company might have fought many litigations on the taxation side, on the labor side.
No,
That
no,
will not save the-
directly connected. Page 65.
that.
Page 65.
6.5.
And you know,
This is the office year, 2020,
this is Milord, yes, this is
94 to 2020.
This is the order dated 18th February 2021. And this petition was filed by the present group of petitioners. And
Did they say one word about the sale deed?
yes,
What they are saying?
para 6, page 66. In the above background that the PIL was filed in 19 February 2020, inter alia praying for a direction to OP number 1 to 3 to take back all lands from the control of OP number 8 and raise an establishment over the land so that the unemployed youth of the area can get engaged in some livelihood. A specific prayer is made to immediately stop conversion of the land measuring 581 acres of land belonging to OP number 8 from Patadar status to Sthitiman status.
On what ground they challenge this? But you have not challenged allotment of the sale deed at all. Not even a sentence is said about that.
No.
Nothing.
No. Then the next paragraph would be germane to this. In response to the notice issued to the present petition, a counter affidavit has been filed by the opposite party number 8.
What happened to this petition?
Well, this petition was disposed of in the ground that there is a petition pending in NCLT, and it's open for you to go to NCLT.
You went to NCLT?
No, we could not have gone there because the issue of locus and the people, those who are from this area, they could not do NCLT.
Wait. There is one famous judgment, na? Under section 527 of Companies Act, earlier erstwhile Companies Act, where because of pari passu, you will have right to you will have locus to approach in those matters.
No, in fact, in those matters, these people were also not, they didn't get any notice from the NCLT.
No, you will not get notice at all.
Yes.
You should go before Muhammad has to go to the mountain. Mountain will not come to prophet at all. He went.
Only I will add one sentence, my lords. In this case, my lords directed, make a wide publication so that adjoining villagers and others, those who have a grievance, they can go and appear before the NCLT. That is how these notifications were made, public publications were made.
Which is that judgment of apex court? Which is that judgment under section 527 capital A was enacted by the parliament after seeing that judgment. Some Menon versus so and so, so and so. Ramakrishna Menon versus or Ramakrishnan versus so and so, so and so. Our professor used to often say that when we were in the college.
Can I just read what happened in this case? Para 70, page 72, third paragraph.
Go to Google, ask like this. Workers pari-passu charges on in company Ramakrishnan versus 83, 84, something like that.
So my not going to NCLT could be answered in para page 72, para 3.
72, para 3.
Yes. After the draft resolution plan is formulated and placed in the public domain inviting objection, it will be open not only to the opposite party number 5 to 7, but others including residents, here we are, to raise their objections thereto under 60 of IBC, which shall thereafter be considered in accordance with law. But therefore, there is no question of we knowing. We have never got any objection. We have never got any...
Right.
No.
This needs a notice to the public at large.
No, that's a different issue. Here the NCLT. Here
that's
the
all right.
yes.
NCLT would not have done anything. We'll assume that way.
Yes, yes.
But the registration, the very standard book on law of registration, like Sanjay Rao, Mullah, they say the object of registration is to make the transaction known to the world at large. Therefore, you can't say you did not have notice at all.
No, I'm not on that issue actually.
No, there even if you go there.
Yes.
You did not go on the ground that you did not have notices may not be correct because there was a public notice.
No, that has to be published. That has to be published here in Odisha. That was published somewhere in Delhi in some English newspapers. So there is no question of these people knowing as to what transacted in NCLT there.
It's probably this National Textile Workers versus Ramakrishnan.
Yes.
1982 Supreme Court.
83 Supreme Court. Correct. You have to, apex court has the Dixit Krishna judgment. Just a PN Bhagavati. He has set the parameters. Only within that parameter, you are entitled to maintain the petition, not beyond that. The points which you are urging are alien to the jurisprudence developed by the High. So, therefore, we are telling you, just go on arguing will not help you.
No.
We understand only the language of law.
Absolutely.
Nothing else.
Absolutely.
Therefore, in the light of that jurisprudence, you have to develop that.
Yes.
Otherwise, you may not get, your client may not get the justice.
Yes. Yes. So the basic.
Keep out that judgment. Yes. We are asking you.
Yes, Minister.
January 1994 sale deed.
Yes, Minister.
For the first time.
Yes, Minister.
When did you raise your little finger against the so-called fraudulent transaction?
Yes, Minister. This entire sequence of events will be appearing in the Read Petition PIL 6779 of 2020, recording all the sequence of events right from 2004.
No, you just show that paragraph.
Yes.
Where the government selling this land for a song is bad. Nearly that sentence. Need not be that sentence. Something meaning thereby.
Yes.
Interest. Yes, sure. And that will be after how many years?
That's in 2004.
How many years?
91, 94.
418.
Thereafter, the first major action in 2004.
2004.
Yes.
What was the prayer?
Prayer is a criminal case.
Now, what is the prayer?
Now, directing that till the disposal of criminal case against the opposite party number
Therefore,
8.
that will not help you.
Opposite party shall not remove any properties from the factory of opposite.
That's all right. That because their soil and test because of this Ramakrishna Niti. That will not help you. Where have you taken up the contention
Yes.
that the government giving this land to XYZ by a sale deed of January 1994 is a fraud on the public property? Nearby, that sentence, something like that. Where have you said?
No, that came only in 22/7.
Counsel, when in a hearing, which is online also, submits.
Kindly have a look at para 7. That itself maybe has some answer. I read only one paragraph.
Yeah.
In response to the notice issued in the present petition, a counter affidavit has been filed on behalf of the opposite party, number 8, in which a reference is made to the earlier writ petition filed by the Mazdoor Union of opposite party number 8, challenging the closure of the company and for a direction to the state government to take over the assets of the company.
That is because of closure of the company.
For running the industry in public interest, and the state writ petition was disposed of by this court in 2004, directing that till disposal of the criminal case against opposite party number 8, which was pending before STJ, shall not remove any properties from the factory.
No, there is nothing.
That's the only thing.
There is nothing.
They shall not transfer the ownership of properties.
What is entire property? So-called leasehold property and not even leasehold because by that time there was already sale deed.
Right. Now the
private property. Yeah. Where have you taken up the contention that the government could not have sold this property?
Page 101. Page 101. Milord, the whole crux of the case would come here. What prompted the petitioners came to the Supreme Court, High Court in 2020 is the attempt by Baladpur Industries before the revenue authorities.
What was the prayer in that petition?
In the writ petition. In the writ petition, it is to pass. That's at page 24.
In that writ petition?
No, in present writ petition.
No, present writ petition, we have already read before you started the argument.
Okay, in the previous writ
petition.
In the previous writ petition, it is page 90. Which conference it is? It's part of the pleadings my colleague says.
No, they're asking you, what was the prayer?
The prayer is
in that petition. Has it anything to do with the prayers made in this petition?
Yes.
Is there any contiguity?
Yes. Para 2 of that prayer says that the opposite party 1 to 3 should not be directed immediately to stop conversion of land measuring 586 acres of land under control of Baladpur Industries from Patadar status to Sthitiban status.
Conversion of land.
That's right.
Where is the whisper
with regard to that
about the so-called illegality in the government transferring this land by way of sale in January 1994?
No, it's not there.
That's not there. You see, the restraining government of a party from converting this land to non-agricultural purpose, from industrial purpose.
So this is where they came to know that this was actually sold in a long time.
Where have you stated that? Where have you stated in your petition?
That's what I'm saying in my.
No, you can't say all that.
In my petition, yes.
You have to say.
Yes. Page 20. Ground. Second paragraph. Can I read that?
Yeah.
For that, the land value of the area of 586 acres are more than 3,000 crore by now, but the government of Orissa is sleeping over the matter without taking any action against BILT, even though the Ballarpur Industries is playing foul play with the common man of the state of Orissa for the last 17 years by closing the company, for which the petitioners and general public have submitted number of petitions highlighting all those illegalities of the government of Orissa and PIL.
Means what? It's a nebulous statement. Nebulous will not help you. You should say what is that fraud played by the government on the people of the state. This is more like an election speech. They should say, where is the illegality? And when you came to know of that?
But in that counter, they have admitted. No, that's right. That's right. My friend says that in another writ petition, the government has filed a counter petition. In that counter, they have admitted to everything.
Admitted to what?
Admitted to the fact that the land has been transferred.
No, transferred is operant.
Yes,
Clearly,
yes.
it itself be operation.
Yes, yes.
Where is the admission? Where is the fraud? Public fraud in transferring this land by way of sale in January 20,
Yes, my lord.
1994.
That's kindly have a look at Annexure A6. Your lordship would be getting it.
All right. The Section 17 of the Limitation Act. Give that Limitation Act. Take that. What is the limitation for setting aside a sale deed on the ground of fraud? What is the limitation? In the schedule. Yes, that's
I
only.
don't remember.
PIL does not relax the law. PIL gives you the forum to go to court. That's all. Nothing beyond that. The rest of the things only law.
Question is, the moment you get the fraud from, I'll see that.
Can anybody tell which is the limitation period for setting aside a sale deed, a conveyance obtained by fraud? Ask them, tell them. Here on fraud, ask them to bring that book. What's the limitation for setting aside the sale deed on the ground of fraud?
3 years next.
Huh?
No.
3 years.
From the period, limitations shall not begin to run until plaintiff or applicant has discovered the fraud or mistakes
Slowly.
or could with
Slowly,
reasonable
that
reasonable
is the judgment of privy council. If you could have discovered, limitation begins.
right,
Whether you discovered or not.
right.
That is the case. That's how privy council said.
Absolutely.
Lord Lingley.
Absolutely.
Therefore, how can you maintain
Kindly have a look. Therefore, this Annexure A6 will be a big help to us.
A6?
Yes.
What is this?
This is at page 83.
Who is the author of this A6? To whom it is addressed?
This is written by the collector to the principal secretary saying that, can I read just one?
No, we cannot read in
At the instant case involves,
read.
yes, yes.
Read jurisdiction.
As this instant case involves protection of valuable government land and available with us, so legal anomalies and factual discrepancies, and as there is a strong public resentment due to the land being not used by BILT for industrial purpose, it is suggested as follows. Ballarpur Industries may kindly be asked to submit all original records in respect of the said land. A committee under the chairmanship of a senior officer may kindly be constituted to verify all the records in original connected with the land. Now, towards the end, it says,
This is dated?
my lord, this is dated 5th
20.
December 2024.
See, under sale, it's a case of section 54.
Yes.
54, Mullah enlists what will happen after sale takes place. What is the business of the government? Government lost all shades of interest in the property because it is not a matter of grant. It is a matter of sale deed. In the case of sale, exchange and gift, all interest and rights of the property of the seller are diminished.
Good.
And they go to buyer.
That's right.
Buyer will deal with the property.
So
How can you challenge that?
that's the basic question. Now that the government says that the property which ought to have been leased to Ballarpur
No,
has been sold.
now collector may say 100 odd things. Government has entered into a sale
So
deed.
that is the reason this Honorable High Court
No.
wants an explanation from the government. Kindly let the government take instruction and find out what happened.
You're not.
So that's the prayer. That is the reason why I pointed out to your lordship the order dated.
All right, your first ground is articulate the ground now. We have understood the articulate the ground. Take dictation now. Yes, first ground.
First ground, my lord, is that this is ground D.
Ground D.
Yes.
Page number?
Page 19.
D. D is wrong. Then that goes now. We are rejecting that ground D because it is not allotment. It is a sale deed.
It is. Yes, well,
The ground D is thoroughly misconceived
no, the point of contention is that
as much as it is structured on a wrong factual premise that the subject land was allotted by the government when it was not. Seven.
that we
The subject lands were allotted, not allotted, but were sold by the government as the owner thereof by virtue of registered sale deed dated 1994.
continuing that
Next.
in D, ground D, the same thing I wanted to continue is, I'm so sorry. The action of Industries Department and Revenue Department in the matter also giving some indication of foul play. Otherwise, the government land should not have been given to BILT, describing Ballarpur Industries as purchaser and allowing more than 600 acres of land at 6 crore rupees only, which is more than 3,000 crore by now, which are going to be sold to outsiders.
Read section 54. Kindly read section 54 of the transfer of property.
I agree that.
Very. E
My lord.
is legally wrong in as much as it is the government being the owner will decide for what price the land should be sold. Once a sale is accomplished under section 54 of the TP Act 1882, all rights and the interests of the seller he is divested of and then to be come to be that vested in the buyer. First, inadequacy of consideration, namely price, is no ground for voiding the sale deed, said the Supreme Court more than half a century ago. Yes. They asked them to bring that mullah on transfer of property. Next.
My lord, that exact figure in this, the land value of the area 586.81.
Not 181.
That's okay, that's over it.
Ah.
For last 17 years.
It is only 333 points so and so.
Now, my lord, only one thing I would be pointing out. It has to be read only in the context of Annexure A6. If I am convincing your lordship only on that.
A6. What is
Yes.
the A6? That letter of the
Yes.
collector.
That's right. Take
Take
it.
that into please. Collector does not say one, he does not whisper about the illegality of the sale transaction at all. The entire collector says, don't allow the industry to convert this land to some other alien purpose. That's all.
No. Kind of para 9 and
Read.
I read. Sorry. Para 9, in this context, it may be pointed out that there are several anomalies between the MOU at Annexure 1 and the RST executed by the Industries Department with Ballarpur Industries Private Limited. The said MOU does not mention transfer of land belonging to through a sale deed, the government land is generally transferred to a company through lease deed under the provision of OGLS Act and rules. Instead of that, a sale deed has been executed by the industry department with the Ballarpur Industries in respect of the land of TPM. It is not understood under what circumstances the said registered sale deed has been executed and whether the said registered sale deed is an appropriate instrument for transfer of government land.
No. Read Section 5 of the Transfer of Property Act. If that collector does not know ABC of law, to say the least, the collector does not know ABC of property law.
No, then further, I read one more paragraph.
We will say,
Yes,
now we will assume, collector say, the sale deed of 24 January 1994 is void ab initio.
Yes.
Whether it will become void ab initio.
No?
But very big. He may say 100 and odd things. That makes no sense. The question is simple. Summoned on jurisprudence. He says ownership is a bundle of rights. And the seller can share bundle or few rights of the bundle to anybody of his choice, unless the law regulates. If the law says you cannot sell your land to anybody, law can say that. If you show the government would not have sold this property under which law, then we'll examine. At what time you can go through that one.
OGLS Act, in that event, that will help us.
Yes.
OGLS Act Section 3.
Which prohibits the government from selling the property. Government is also a person. It's a legal person. Jalan Trading Company versus Finestone. It's a legal entity. It can do whatever the other legal entities can do, unless through law regulates it, controls it, modifies it, and says the government can do only this, etc. That's the law.
That's absolutely right.
Yeah.
No, here my submission is that this is a property which ought to have been transferred by virtue of a lease to the subsequent company. Now, had it been under lease, then Section 3B of OGLS Act would have applied.
Great.
Now that they have sold it,
No, actually,
What are the mode of this?
transfer.
Is there?
Suppose I enter into a lease transaction with you and I put the property into your hands. Can't I sell that property to you? Can lessor sell the leasehold to the lessee or not?
yes, yes.
It can. There lies
Now the question is now that whether the sale was bona fide or not, the sale was causing public injury or not, whether this is in public interest or not.
section you are reading.
So, in OGLS Act, I was reading 3B. Had it been a lease property, it would have been resumed because they did not use it for the purpose of industry.
But they have sold it only.
That's all. So therefore, this.
Then how this section will come to a
No, my submission only to this extent, my lord, since. That's it. As your lordship felt it right. Got it right.
Any other point?
One state of Telangana judgment I came across. Wherein Telangana.
The limitation period for setting aside a seat on the ground of fraud. Which article in the schedule? Mr. G, which article in the schedule? To the Limitation Act. Can anybody enlighten the court? What is the limitation period for setting aside a fraudulent sale? Which article in the schedule to the limitation period?
Parak 22 to 24.
What does it say? Sir, we have one request.
That's it. I'm ending it.
First, you should know what the judgment says.
Yes, yes.
Then you should ask us to read. You can't ask to read the judgment to know what it is going to say.
No.
You should say, this judgment says like this.
Yes.
See this.
Yes, yes.
Then we can. What does this say?
So here is a case where the government had sold a land and ultimately it turned out that. And then Supreme Court said, no, this the purpose of transferring the land was for a public purpose.
Which year land was transferred? Which year challenge was made?
Yes. It was
transfer of which year?
It was of 1990.
Sale deed is of? Give the date of sale deed. Give that judgment.
That's
we'll also read with you. Give that.
19, huh?
And when the case was filed for challenging that sale deeds?
Writ petition was filed in 2013.
It was not by government. It was by the district collector.
That's right.
And it was not a sale. It was an allotment.
No.
Kindly held. First point.
No, but subsequently it was sold. Right. Yes, it was allotted, subsequently sold. Seven.
Paragraph 7. Kindly see that.
Yes, ma'am.
First, the whole structure of the judgment is, how are you going to take out the ratio decidendi of a judgment? Two tests. One is Dr. Upendra Bakshi test. Another is Professor Woodrop's test. That is the Wambach's test, Professor Wambach's test. These are the only two tests by applying which you will take out the ratio decidendi. Kindly see what are the foundational facts of that case. It was not a sale, but an allotment under a statutory scheme.
Initially, it was an allotment.
Under the scheme.
Yes.
In the light of that, apex court found this you could not have done.
No, it was
This is
subsequently
not
sold.
correct.
Yes.
But earlier transaction was under a particular scheme governed by the legislation.
Yes. So now here is a case where for the purpose of developing industry was initially allotted. Subsequently, when it became sick, Ballarpur industry, the property should have been transferred. It was sold. Here came the breach. Now, when matter came before for the purpose of revenue, what is that called? Mutation. Then only people come to know that a fraud had happened long time ago, and that is how everything came in the open. Yes, yes. Telangana just Telangana Para 22 will be my last submission. Para 22 will be my last submission.
Counsel for the petitioner pressed into service the apex court decision in state of Telangana versus Dr. Pasupuleti Nirmala Hanumantarao Charitable Trust. ये Manu SC 90/2025 para 22 in particular. To the effect that the state cannot alienate its property except by modes prescribed by apex court in R.D. Shetty versus International Airport Authority. First, it stands on a footing much different from a private owner when disposal of largest issue is involved. Yes.
That's
for OPs. Yeah. Right. Just tell us which is the article in the statement. That's telling us it's CLD. 56, probably 50. There might be two. One is when possession is taken, and another is when possession is not taken. There are two articles.
It was registered. Instrument was registered within 3 years from the date of
registration. Where instrument is registered, but seller retains the possession. There is another article, Apex Court 72 Supreme Court.
But so far as this case forgery is concerned, that is in 56. Entry 56.
Article 56.
Minutes.
Read.
To declare the forgery of an instrument.
That's not a case, sir. Forgery of a document is different.
Yes.
Fraudulent sale is
fraudulent sale. Fraudulent sale.
You should have clarity of ideas first. That comes by reading the best books on jurisprudence. Otherwise, very smuggy arguments. Everybody
that's correct.
Put all blame on us when we write the judgment. Yes. Forgery, fabrication, error on fraud says they relate to the instrument. That is not his case.
Fraud.
His case is public fraud because public property 333 plus acres of land, you have taken it for a song is their worship.
People enter into all these things.
Who are you?
I am the Balapur part number 10 to 12. Balapur Industries. 10 to 12 Balapur Industries. But now
whom sale is given?
No. My property is under my lord's liquidation process, insolvency process.
No, to whom this property is sold?
To whom?
333 acres lot.
Sold it to whom?
Government sold it to whom?
Balar Planet. I'm Balar.
You are, that's what. You are the buyer of the property.
Yes. Before entering into all these things, my lords, may I submit, my lords, three things. I'm not going into the record. What the government did is, after getting the order from VIFR, government made an advertisement inviting all these stakeholders, these industries, those who can come and participate in the auction. Thereafter, my lords, Balarpur was chosen.
It was auction sale.
Yes, it is an auction sale.
Show that. When the auction was held, what were the terms of auction?
That is, I will point it out. Let us go ahead. I'll point it to that point. I will tell you.
Yeah.
That is there. There is an observation to that effect in that record document. Thereafter, Balarpur was selected. Then,
that you have to, if you say in the auction process, for the auction process, Balarpur something, Balarpur was selected. Where is that?
I'll come to that. I'll find out from the record at particular that this has been observed. I will show that. I will show. Now, my humble contention.
Yeah.
I'm not going into this or that. My humble contention is very specific about maintainability of the petition. Fact remains, these petitioners, in the year 2004, they have come with some prayer. The government filed a counter, stated that yes, this has been sold and all these things.
What was their prayer?
Prayer matters to interfere in this matter, matters?
Interference means what?
To the same prayer to set
aside MOU. Where is that? Show that. Don't make speeches. Kindly tell us the prayer. Where is, what was the prayer when they came to court in 2006?
I'm reading the portion of the counter that was filed by the government. Out of that
prayer you have to read, no?
That they petitioner in the read petition prayer the Honorable Court for a declaration to the opposite part number 1 to take over the industries in question and to ensure its full-fledged utilization and for running of the industry to make all required arrangements with the involvement of the experts and to take steps for making the industries.
Then it was not a prayer.
Modernization, modification as may be necessary for the purpose. The petitioner further pray for the Honorable Court.
It was for revival of the industry.
Honorable Court, revival, to declare the natural resources like such and such and such that is there. This is the case. But now it's a very simple point.
Yeah.
This sold it, government executed this sold it. Referring to my countermeasures. What happened in this?
Your friends can go for a round, coffee round, if not for the meal. It will take some time. Very.
Yes,
no, the persons who are waiting, it will take some time. We will be very happy to see you all sitting in the court hall is another. But if you want to go, you can go and come back. No issue. Yeah. Your first ground is what? First ground of resistance to the is what?
But the first ground is this is a deed executed by the government, repeated by the governor. Way back in the year 1994, what minors have already taken note of. 1994. Thereafter, minors, another set of writ petition have come before the Hon'Ble High Court. During pendency of the insolvency proceeding. Hon'Ble High Court dealt with all these aspects and my learned friend has enclosed that writ petition.
So articulate the ground.
What?
Articulate the ground of resistance to the petition.
Exactly, I'm coming to that.
Then facts you can narrate.
So my first point is concerned. Once a set of persons have come in a PIL and filed the writ petition, and thereafter the Honorable Court passed an order requiring the NCLT to make a publication so to allow others to participate. But without participating, then again coming and challenging this in the petition.
Not permissible.
But
Right. Petitioners and others having approached the court in PIL jurisdiction way back in 2006
2004, man.
or 2004. The said PIL was disposed of.
Dismissed.
What is that? 2004 rate. It is only in 2006.
Which one, madam?
Petition is of 2006 or 4?
12625 or 2006.
No, madam. That is petition, madam.
Yes. Right to that, there is no reference to anything.
That is
Your date chart doesn't say so.
on date, that is WPC number 11338 of 2004.
That means mention.
A copy of your date chart, please.
Did not?
No, So kindly repeat WPC.
11338 of 2004.
WPC 11338
38.
338 of 2004. Come on. The matter was what they said, what said,
Yes.
what the order passed in that. Where is that?
Directing.
Yes.
Dismissal.
No, that is only.
Dismissed for default, but they didn't pursue. The petitioner was there by
The same was dismissed for non-prosecution. Void order dated.
order dated 2009, madam, particular order.
Your date chart does not mention that.
Yes, that is. Hmm? 2009, but particular date.
Eh?
It was in 2009, but particular date, my husband.
Both the completely each other. In 2009. Now it is not open to the petitioner to lay a challenge to the 24/1/1994 sale deed. Correct.
The second part is that the admittedly liquidation proceeding going on, but that insolvency proceeding, Hon'Ble High Court directed.
In which case it was?
Well, that is in the case matters, and that is
6009. 6009.
666
In WP number
6
679 of 2020.
6779
Dated 8/2/2021.
18/2.
18/2/2020.
in WPC number so and so.
There, Hon'Ble High Court considered the grievance of all parties.
The coordinate bench, having considered grievance of all the
And directed, if anybody has any grievance,
they should go before the
NCLT.
directed that anybody having any grievance can work out the same by moving appropriate proceedings before the NCLT. First off, this was wide order dated
But it's ordered at 18/2/2021.
2021.
This is what I had pointed out, but wherein the last paragraph I had said that there has to be a publication. Only after the publication we could have gone. And that is delivery Odisha. That's what I had pointed out during the course of my argument.
Yeah.
But it's now, I'm to answer that, Manoj. There is, pursuant the order of the Hon'Ble High Court,
Ramakrishnan.
National Textile Mill versus Ramkrishna.
NTC versus. Ramakrishna. Yeah, it is Supreme Court. HSC 75. Okay.
Thing is that my learned friend now pointed out the thing. I have to point out. Honorable High Court categorically directed to make it public one. So inviting objection suggestion also. My learned friend,
who should issue the public notice?
The public notice means that resolution per professional. The resolution professional is liable for all this. Have to comply all this. With the resolution.
At that time, any proceeding was pending. When
that pendence of that. The proceeding was pending.
That was what proceeding?
That NCLT insolvency proceeding. NCLT, when I wanted that number.
IVC proceeding it is.
Number. CP number.
First off, it was in the wake of pendency of IVC proceedings in CP number
2915 2019. At a Mumbai bench.
Pending on the file of Mumbai bench of NCLT. That was initiated by whom?
But that was initiated by all the financial creditors.
That was initiated by the creditors of BLP. What is that?
Balarpur Industry.
BILT company. Okay. What was the order made in that?
Well, but that particular NCLT passed an order that I've given the detail. They appointed a resolution person, and they required the applicant to submit the proposal. The proposal was submitted.
Whether any public notice was issued?
Yes, but that is what I'm pointing out, minors, that notifications, all these notifications have been closed in my account.
Which is the public notice? By which order?
But order of my minors of the Honorable High Court, that was complete and detailed.
NCLT order.
And that is kind of a glass to page 106 of my counterpart.
Which is the date?
The date is 3rd May 2022.
Public notice.
Public notice. That is
the NCLT by the order dated?
Honorable High Court and order. That has been stated here. The order of Honorable High Court in 2000. That has been stated categorically. Whenever I will read the English version. The instant public notice is page 108. That is in English.
That looks like a Pune publication.
Pursuant to coordinate benches order in WP number 6779 of 2019, made on 18 to 2021. Resolution Professional of Built, VILT, had issued a public notice mentioning about relevant parts of the resolution plan, which referred to the land in question. First off, the publication was made in as many as 16 newspapers and different languages, of 5 different languages,
including Odia.
Odia. Which is the newspaper?
That is Pratidina.
That is Pratidina. It's prevalent. It is circulation is in which place?
In the state of Odisha.
Very
So far Odisha is concerned, it has in all these districts circulation.
They have it at it. Having circulation throughout Odisha, you know.
This is of which year? This newspaper is registered in which year?
Paper.
Huh.
No, that was published.
That is publication.
Registered minors. Postal registration is there. That part is not there, minors.
Public notice made, Apex Court said, it should be in the newspapers circulating in that particular area,
Minors.
and which should be in the language known to majority of the people of that area.
Right.
You suppose in some XYZ newspapers, if you publish,
Minors.
how people will know that? How many newspapers were published? Mode of circulation. Everything should be stated.
Minors.
Otherwise, you will print all newspapers and you will buy yourself and keep it into your drawer. How
That is not
public
there.
will come to know?
That what my lord says is correct. But in my humble submission to that is very specific. That in the one we have enclosed it, that is reported in Procedural, it is in widely circulated daily of covering Orissa.
First off, council submits that that publication is of 18 to 2021 and it is in language. There is another anomaly now.
Minors.
Odia language newspaper publishing English notice. On that there are judgments.
Yes.
If it is in Odia, people will read. But if it is printed in English,
No, it is
in the Odia newspaper.
Right, man. Our High Court also, Hon'Ble High Court Justice Chauhan's decision that is there in respect of an auction.
Correct.
So it should be in Odia.
It should be in Odia.
Because local people, they should know.
Will not know. They think that it is some as your transport department advertisement or your Bali Yatra. We are not concerned with that, therefore we will not read. Therefore, it should be in a language known to majority of the people.
But property situations.
Ordinarily are presumed to read this newspaper.
Yes. That is in
The
Odia.
same newspaper,
Is in Odia, minors.
though in Odia, publishes the notice mentioning the PIL WP, which and the said notice is in English.
In Odia number?
No, Odia also.
106.
106.
Page 106.
Council point you have put it all reverse and reverse. No, it's reverse.
I have shown it, minors, because it is written in English so that minors can appreciate.
Council also points out that in a notice in Oriya is also published simultaneously.
Yes.
But a copy thereof is at page number
106.
10. Outer. Yes.
Now my question is, the sale was, minors have already pointed out, the sale was made way back in 1994. And now we are in 2020. They have raised that point. Let us consider that in 2020. And in the meanwhile, a substantial period has passed.
Next one. Council submits that the petitioners, apart from lacking the locus standi and locum, have approached the court with a long delay, which has remained unexplained. The sale having taken place in January 1994, and therefore the challenge to the sale deed cannot be entertained. First, he tells us that under Article 56 of Scheduled to the Transfer of the Limitation Act 1963,
Read with section 17.
read with section 17, the period for laying a challenge to the sale deeds on ground of fraud is 3 years. 3 years. It also points out that the period of 3 years arises from the date of knowledge or knowledgeability. Yes. Next.
Minors. Then my humble submission would be that public notice given. Honorable High Court has already given a direction. Pursuant to that, public notice has been given. And thereafter, again, another set of people, those who are coming and filing it. One set of people earlier set up. Now another people, they are and filing this.
In further tells that pursuant to this public notice, the petitioners did not avail the opportunity of taking up the steps and appearing before the NCLT. Next point. Other set had come.
Means
Other set of
now the petitioners are other set of persons. Earlier, other one set of persons in the 2004, then minus these people.
which is that judgment which says orders passed in PIL jurisdiction operate as res judicata as against the world at large. They are REM
Yes.
orders. In REM orders. It is association of manufacturing, steel manufacturing industries versus so and so.
No, minors, I will sort it out, minors. I
This
release
judgment we need, na? All updation is lacking so much. I never entertain the argument at all. Boring argument. Inevitably, I see. I have nothing more to learn from you people. That kind of arrogance is coming in me. That's
obviously to all also.
updation. Where is the jurisprudential quality of the submissions? Any branch of law. Nothing, no research, nothing. All coming to the court like those coming to the chowdhury for marriage and other such other functions. Where are the quality arguments? Where are the points you are articulating? Where are the best books on them? Where are the best rulings on them? How law has marched from X to Y, gradual moment? Nothing. Coming and saying and going and very sorry to say this. I should, as an outsider, I should not say, but I am not an outsider. I am one amongst you people.
Yes, that's correct.
Yes.
Plus, minors refers
No
to that.
good books are cited. No good books are cited.
Minors here in this case,
No
of course.
good jurisprudential work is cited. No rulings are cited. Nothing is shown how the march of the law has happened. It happened like from X, then it went Y, then it came this side, then it took a tangent. Nothing.
So in depth,
Then
minors.
your youngsters should follow all of you.
And that is one part, minors, that in your minors required probably to know about that res judicata, prospective res judicata, that is
It is the
the
judgment of the apex which
that is
said
the national
order made
confederation.
PIL operate as res judicata.
That is the judgment of
National confederation.
versus Prabhat 86 1 SEC 100.
86 in SEC 100.
But,
Thank you.
A decision in a bona fide PL operates as judgment in res.
Correct.
It can bear subsequent PLs on the same issue under the principle of res.
Thank you. Minors refers to National
This is the
Confederation case.
result.
No, National Confederation case, minor, that was 2021. National Confederation of Office Association of Central Public Sector Enterprises and Others versus Union of India. 2021.
20. What is the citation? Give that.
National Confederation.
Name all. 2020. Right now.
Now, question is, must the kind of a glass to page 317.
Page
317.
317.
Yes.
He says that one set of people had come before the PIL court and had taken some orders, and therefore the second set will not come and seek the same or similar relief. Comma. Or the bona fide orders made in PIL jurisdiction operate as res judicata at world at large, if not in REM. No. They are not, may not be in REM. They are res judicata to everybody. That's not saying one thing. Res judicata is one thing, REM is another. REM orders are made. This is what our professor used to tell us. Matrimonial jurisdiction, insolvency jurisdiction, and probate jurisdiction and admiralty jurisdiction.
Admiralty.
Yes, these are the only 4 jurisdictions where REM orders are made. Yes, section 42, 43 of Evidence Act. Yeah.
May I submit minute now? I'll have a glass to page 60. This is the resolution made in a meeting chaired by Honorable Chief Minister concerning these properties.
Which is that?
Minute page 60 to my done 29/1/1992.
So state, the highest executive of the state has deliberated on the matter.
deliberated on the issue. May I read it, manner. The Honorable Chief Minister was kind enough to review the implementation of the scheme of relief of the concession granted to Ballarpur Industries in respect of erstwhile TPM. Earlier it was TPM and Seva Power Limited as per BIFR award and MOU. These present in the meeting, those present in the meeting were in Annex A. So, initiating all these things, kind of state for page 61 relating to
the chairman OACB. The chairman OACB state, page 61, you said, no?
Page 61, Revenue Department.
No, this is Orissa State Electricity Board.
Various stakeholders were there. All the stakeholders are there. So far as the Revenue Department is concerned, that last portion, page 61, last paragraph.
Referring to para 3, page 3.
Relating to transfer of the asset and liability, including land, clause such and such granting exemption of payment of stamp duty, registration. Secretary Revenue mentioned that transfer of land may form a part of the composite transfer of sale deed of the entire asset and be given effect to by execution of the deed of conveyance, transfer by and between the parties. This will be attended to on priority basis.
What does it say?
It says
registration. Registration is not necessary because of that section in the Registration Act, although it is registered.
No, but registration will be there. But fact remains, we are paying two on the stamp duty stamp and on the Registration Act registration. Presently, minus 5%, 2%.
One section in the Registration Act where sale deed is executed by the government or nominee of the government. It is deemed to have been registered is a section. I remember.
But fact remains, in this present case, it required a notification to that effect, giving relaxation so as to execute the deed without payment of the stamp duty.
Stamp duty.
Stamp duty and registration fee. That is, to that extent, I will kind of glance to page 317.
That section which exempts government conveyances from registration. So that order was made. Exemption.
Exemption matter, that is with an actual amendment. That is at page 317.
This is amendment to the policy.
Amended policy. Pursuant to that manners, page 319. Next up, B by 10.
Next point. Council points out that a high-level meeting under the chairmanship of the Chief Minister was held on
minus 29/1/1992.
92. 29/1/92.
92.
29/1/1992 with the participation of all stakeholders, including the
collector also,
including the Revenue Department, Electricity Board.
Page 65. The name of all union, page 65.
So,
RN Misra, IS 13, serial number 13. The collector.
Revenue Department suggested exemption from stamp duty. In terms of this suggestion, the policy itself came to be amended while notification dated.
That is notification dated 11th November 1992.
Providing for exemption from stamp duty. Pursuant to that, the government issued order number 53774 dated 5/11/1992. And exemption from stamp duty was accorded, correct? $33.34.
That indicated that particular total area that exemption was given, that has been indicated. But now, the resolution applicant appointed has already been appointed. Insolvency process in that is in the last stage. You have filed a writ petition. The thing is that within 3 years, the applicant is to comply. That is going to end by March, 31st March. We have all the company, the resolution applicant, already deposited almost total 700 crores deposited, and debenture have been issued in respect of the other financial creditors.
Thereafter, the sale deed came to be executed and registered on 5-1. Registration also happened?
Registration, super registration was in my favor. Yes, 1994.
On 5-1, 1994. 94. First one. Now the proceedings are at the final stage at the hands of NCLT pursuant to the resolution of the professionals resolution. Professionals resolution.
It's called resolution that resolution applicant. The total plan.
And the last date being 31st of March 2026.
Expiring 3 years, my lords, from the date of the order passed, the resolution plan approved.
3 years. Come on. Now the petitioners have woken up and come before the court and therefore are not into any relief at its hand.
Now, my lords,
whether they had filed any objection, anything paper with the resolution professional?
no,
Nothing.
no.
He also points out that the petitioners had not lodged one piece of paper before the resolution professional after the public notices were issued.
Now what happened in this earlier writ petition, collector has filed an application stating clearly therein that yes, this property has been sold. That is in WPC number 11338 of 2004. There the counter filed by the collector as agenda matters. Part of the industrial department. That reads like this matters. The state government had executed the sale deed with the bill dated 5/1/1994 pursuant to the MOU.
Page number?
Yes?
Which page you have read?
No, that is the affidavit file. That is not there. Only just for minors information. Executed sale deed with 5/1/1994 pursuant to the MOU. State government has already transferred all the asset and liabilities of erstwhile M number 3 in favor of build, and as per the terms and conditions of the MOU, build is the successor in interest of the company. After transfer of TP number 3 build, state government are no way liable to any liability of the company. Build has become the lawful owner of the company. So that is the affidavit filed in earlier writ petition. Now I am to point out one thing. Collector has given a representation what my learned petition letter minus in annexure 4. Collector has written something. But to that matters, my humble submission, the file is again mooted to the law department. Law department on threadbare analysis of the provision of law with reference to the judgments what my lords wanted, must give in their opinion. That is at annexure Q by 10.321. Counter-appellate.
How could you get?
Page 321.
Start from page 321.
322.
321 starts from 5.
Pursuant to collector's proceedings dated?
No, it's of 2015.
2015. The matter ultimately was referred to.
So that is
the law department.
Probably, but it's not. Earlier during 2015, a dispute arose. That is how it was sent. Whatever collector required in his application to be clarified, these all things have been taken care of by the law department.
No, the date of collector's
24.
proceeding.
So that is 24 months subsequent. Earlier it was referred to again.
Before this only. Earlier it was 2015.
But it was 2015.
8/12/2015.
8/12/2015.
8/12/2015. because it is like a matter ended at the level of the law department, which by note sheet dated
Note sheet dated that is
28/7.
28 September 2000.
name of fraud, 13/1/2020. Signature. Oh, sorry, 28/9/15.
8/12/2015.
That is 28/9/2015.
No, 28/12/2015.
12/2015. 8/12/2015.
He refers to one judgment which is overruled. Lakshmidhar Naik versus Sridhar Naik, 2009, 1 CLR 553 is an overruled decision. Check that. I assume that it is a overruled decision.
Yes. That overruled decision, that will check it. Overruled decision is suppose that Lakshmidhar Naik matters.
Earlier view was the passing of consideration is not a sine qua non for validity of the sale deed. Person who is that rights of the unpaid seller. This is how Mullah treats in Transfer of Property Act.
Yes.
He says, Mullah suggested, rights of unpaid seller is to sue for the money. But that view is loosened by the apex court. But he is citing a same decision.
The decision in the contest matter. The contest is important. It has been held that sale by registered instrument is prima facie transfer of title to the vendee. Mere non-payment of the price.
That itself is wrong. This is what Mullah said. That mere non-payment of price is not a ground for invalidation of the sale deed. He can
only right of recovery.
recovery of the
Right of recovery is there.
Point.
Right of recovery.
Section 54. Mullah has so beautifully dealt it. Rights of the parties before sale deed, post agreement. Rights of the parties after the execution of the sale deed. Very beautifully has given the chart itself. I remember I read on you.
I am reading few of the paragraphs, 324.
Whether you had remitted the money for this sale deed.
Then immediately after payment of the money, sale deed was executed.
Where take us to the sale deed where you said you have remitted the money and money is received. How it was paid, how the sale deed reads, let us see.
Next,
Sale deed, your lordship. Para 4 of the sale deed.
Para 4.
Yes. Of the sale deed.
Annexure 2, page 40, starts from page 40, that the read petition matters.
In consideration of
Internal page, internal page 3.
Consideration of so and so. Where is the remittance? It has already been paid.
Already been paid.
You are right. Legitimate law. The law department structured its opinion on a premise that regardless of the payments of sale price, sale deed would be valid. However, we need not spend much time on that. In as much as sale deed of 1994 specifically mentions remittance of the sale price by the buyer, that is built by BILT, by built. First time. The sale consideration is stated to be 12 crore for entire land, which included the leasehold of 334 acres. All right, next point.
No, my humble contention, threefold. One, in different contest, some of the persons, agreed persons, in right or wrong manners, they have come before the Honorable High Court All these decisions which has come up, that let us forget about that. The last decision being of 2020, and there is an Honorable High Court in Division Bench categorically stated and made a position, 1, 2, 3, three directions, specific directions. And in these 3 directions having been complied with, thereafter again coming before the Honorable Court in another way, just changing the nature that to prayer portion, meaning the same thing, not sustainable.
Which is that earlier one more petition?
That 2004 matters?
No, not 2004.
2020.
2006 you already mentioned.
2020 matters. That is in Annex 3.
2020.
Annex 3.
What was the nature of case it was?
PIL. It was a PIL.
PIL.
Filed by
the prayer.
That is at page 65 minutes.
Six, 7, 7, 9 of 20.
Minutes.
6, 7, 7, 9 of 20.
Minutes. 18 to 2020.
Okay.
No, para 3.
Pointed out page 66, para 6. Same. The one
You already did that.
Yeah, that's what your lordship is referring.
Already.
He also draws our attention to this is DB order.
It's division. By
The
just
coordinate
this,
bench order dated 18 to 2021 in WPC PIL number 6779 of 2020. All PILs in DB in this court. Which to an extent gives the earlier rounds of litigation. More particularly about the NCLT proceedings.
which was so wonderful.
First off, the coordinate bench permitted all the stakeholders to register their objections before the under section 60 of the IBC with a direction to NCLT to consider the same. First one, writ petition is disposed of with that observation. Okay. Thereafter, what happened? Then the collector sent this letter to the, this is 6/6/2020. That was disposed of on? Disposed of on which?
Collector's representation before the
Collector's letter minutes. That is Annexure 4.
Annexure 6.
Annexure 6 minutes. Sorry, Annexure 6. That is written to minutes.
4 and 6 are same. What is different? 6 is.
This was written in 2020. 6/6/20.
What does it? What also says? Now what happened before the NCLT?
NCLT minors resolution plan has been approved. I have given that resolution plan in
Approved on?
On 31st March 2023.
The resolution plan suggested by the professionals has been approved by the NCLT, wide order dated 31/3/2023.
Minors.
After noting all objections.
All objections. Final order passed.
All objections. First, he points out that petitioners never raised any objection before the NCLT. First,
The resolution plan I have given
We'll come
minutes.
back. We'll come back. Right.
In 13 matters, some outside counsel is appearing. As you also appeared. 9 and 13.
13.
So can it be Thursday? Or
Where is that outside?
he's not there.
You got a proposal to him
Otherwise, after 2:30 tomorrow it can.
tomorrow.
Tomorrow or after 2:30. This
There is urgency in that.
Not urgency, but because he's coming outside, maybe.
Let him come. Wait.
My associates are there, my lord. I'm just leaving. Mobilize.
Item 1? Yes, sir.
Now minutes I will cut certain things. Only pointing out one thing. Minutes in the meanwhile, after complying all formalities, NCLT minutes approved the resolution plan. That is kind of goes to my counter.
It is approved on
Minutes.
31/3/2023.
Revised the resolution plan is Annexure K/10.
Yeah.
Then it was approved by the NCLT
On.
order dated.
You said it, not 31/3/23.
That is on 31st March 2023.
Yes.
Thereafter, one of the competitor went challenging this resolution plan before appeal before the NCLT, and that was rejected. That order also I have given.
NCLT, wide order dated 31/3/2023, has already approved resolution plan, and that the same was challenged before the NCLT.
In company appeal number, bracket 80 insolvency,
80
bracket insolvency 17 and 518 of 2023.
that came to be negatived. Wide order dated.
This order dated My judgment, the judgment dated 4th July 2023.
4/7/2023. But then what happened? Whether it attained finality and a further challenge was laid to this.
That is after final.
No further challenge having been, the same as
No,
attained
it's pending in
finality.
Supreme Court. The other one, there is in relation to, is this civil appeal number 426 point?
No, that is just separate.
I'm so sorry. There is a connected matter pending in Supreme Court in relation to this.
Approval.
Yes.
However, counsel for the petitioner points out that there is some challenge to that order on the floor of the apex court in civil appeal number
4265 of 2023.
Immediately there.
4265-4266 of 2023. Some order appears to have been passed in that.
Any transaction and payment made, the secured interest of the appellant would be subject to outcome of these appeals.
And that some order has been made at interim on
It's your annex, sir.
17/7/2023. First one. Challenge is said to be pending. Yes.
Now, I will point out matters. The resolution plan approved has taken note of that property, this present property.
Counsel for the petitioner points out that in view of decision by the apex court justice Ram Session, which is that judgment you cited, na?
So initially, the one I cited. The judgment is cited.
Rama Subramaniam, the challenge in PIL to the transaction in question would not come in the way of orders made with the NCLT or NCLT. You cited, na? In the
Embassy
pre-prendial submissions. Yes.
Embassy.
There my kind of class to page 233. Page 233 of my counter.
What is that?
That tell me the Chaudhara land. Various lands are in various part of the state are there. I am not concerned because here we are concerned about Chaudhara area. That is what I am submitting Chaudhara land. How the plan has considered
The land situated at
land by situated in different part of
was there.
land is situated in different part of land in different part of the state.
This company owned land.
500 places.
It's not one single packet.
No, at different places.
Here minors were specifically concerned about Chaudhara land.
Chaudhara.
That page 233, how the settlement by proposal dealt with. The resolution applicant concerned that Chaudhara land had been secured in favor of Edelweiss
This is the one I was referring to.
as company limited as security for the credit facilities granted to build graphic and something which are partly granted by the corporate debtor. Edelweiss ARC is thus a secured creditor of the corporate debtor within the meaning of the code. However, the resolution applicant understands that there has been no default by BGP obligations and the security has not been enforced. None of the creditors have charged over the Chaudhara land. Chaudhara land will be sold by the resolution applicant and the sale proceed will be utilized in accordance with the resolution plan.
What is this order about?
But order means there a lot of allegations are made whether it can be sold or not.
Who said this? Who is saying this?
And how the money will be paid?
How many?
700 crores.
Let's make a submit something. Total transaction 700 crores. 400 crores were deposited to satisfy some other purpose of the creditors. Now, this is one part where from it will get
To generate revenue, you have to sell this and do that.
That is what the learned NCLT dealt with and allowed that you sell it and you get that just thereafter a sum of rupees 277 crores to be paid to the financial creditors who are entitled thereto in terms of the resolution plan out of the sale proceeds as and when the asset in question are sold and sale proceeds received.
So that's what you want to make out by that.
But my humble contention is that in so that NCLT order approving the resolution plan has dealt with Chowdhury property and has made out the position that it would be
But the point which he has raised, that aspect has not been noted. This is contention. The point which he said, the public property cannot be sold by the state just by entering into a sale deed.
Yes.
It has to be in terms of Raman Dayaram Shetty, R.D. Shetty. That process has not been done. And coming to know of that, we have challenged this. And he also, Apex Court decision is cited. Orders passed by the NCLT will not come in the way of that challenge. That is his case.
May I submit matters one thing? Here in this case, a special statutory authority who has been constituted for that purpose has come into conclusion and has settled the position what to do in accordance with that act. And that has been finalized but approved by the...
That is what that Apex Court said.
Yes.
That will not come in the way of challenge at all. No? Take out that this 2019, that embassy property.
Yes.
That itself. The upshot of the above discussion is that though NCLT and NCLT would have jurisdiction to inquire into question of fraud, they would not have jurisdiction to adjudicate upon disputes such as MMDR Act 57 and the rules issued thereunder, especially when the dispute resolved around decisions of statutory quasi-judicial authorities, which can be corrected only by way of judicial review of administrative action. Hence, the High Court was justified in entertaining the writ petition, and we see no reason to interfere with the decision of the High Court. Therefore, the appeals are dismissed. This is what he read.
May I submit matters one thing? In that case, the very pinpointed a particular what is fraud.
That's what.
Here in this case, there is no allegation of committing in fraud.
No, fraud in the sense. Fraud on the law of public property. You can't sell a public property by sale deed.
Yes.
Except by adopting the known modes of disposal of state largesse. The state largesse, R.D. Shetty says, Raman Dayaram Shetty versus International Airport Authority says, public property can be disposed of only by auction.
Now let's make one line only. After 1994, the sale deed executed. Thereafter, it is the property of that particular company.
Correct.
So the right of any contention claiming that it is a public property after the sale deed was executed and the title passed.
Only thereafter that question arises.
But
if it is not sold, question will not arise there.
that is correct, balance. But here in this case, in the year 1992, the considered 4 proposals given, government considered 4 proposals given, and thereafter said, I'm submitting my side.
Counsel submit, counsel for the respondent submit that everything having been looked into by the NCLT and NCLT, matter has been finalized, permitting
Resolution applicant.
Resolution applicant to dispose of some of these properties for raising funds to meet the notified creditors of the company.
Yes. Here in this case, probably one thing weighs in my mind, whether it was given to me or other participants there and on negotiation government has given to us. But to that effect, I have not only one paragraph minutes, kind of last 2 minutes, the read petition page number 29.
Page 29.
Page number 29.
What it says?
But the matter, I am reading it from line number.
No, you should say the gist and then you should read.
There it stated that after this matters, the we for contingency come for rehabilitation, then matters 4 participants were there. But that in detail the paragraph MOU has written that. But may read it, but during the period of rehabilitation, 4 parties, namely Straw Products Limited, Ballarpur Industry Limited, Hindustan Paper Corporation, and Oriental Paper Mills Limited, has shown interest to revive the mill number 3, such and such, and has given their offer to the state government. After the award of the revived receipt, it was found that the anticipated liability of the mill would be about 24 crores. And the state government called for reaction of all the 4 parties. Only 2 parties, namely Straw Products Limited and Ballarpur Industry Limited, reacted to the offer. After examining all aspects and in view of the finding that less concession has been asked for from the state government by VILT, who gave an offer of 12 crores, government took a decision to induct this established institution, industrial house, to reopen the mill and commence production at the earliest and communicate their decisions. It's not that it has been given to me. But all the proposals were examined by the government.
No, that's not it. He also draws attention to connect that to the contents of MOF January 20, April 1991,
Yes.
which mentions certain facts and circumstances as a prelude to before January 2020, 1994 sale deed. First off, he stresses that there were totally four agencies which had a kind of claim in respect of the subject property, and that the BIFT, the claim of BIFT being comparatively viable, comparatively viable, while that of the other three came to be accepted.
My humble contention, the property has already, after negotiation and all these things, government consciously took decision in a different meetings they resolved. So they also considered who has given, what are the
you have said that. No,
what are the things?
Chief Minister headed the committee, etc.
All the letters are given there, 3-4 letters to show that Chief Minister taken that meeting.
Let us see what government will say.
That will see. My humble contention, here in this case, twofold. I'm buttressing the situation on twofold. One, in a case where the person, one of the party who filed the writ petition, PIL writ petition, and in his presence that PIL order was passed, at least he could have, or any of his persons could have appeared before the NCLT. Had they any regard to the order of the Hon'Ble High Court? And you have not appeared, not participated. Now his statutory authority must the
that question arises. He says, after the publication of the notice, we did not know all this at all, is his version.
But I thought to that man, but to that man I have submitted that notice, public notice of
that contention is now over. Any other?
Second, minors, you have not appeared, US has gone off. Concerning the properties of built, it's no more a property of the government. Government already sold it, has taken the consideration. Now it becomes a private property, like a company's property. Company's property is subjected to, this insolvency proceedings to deal with and to manage the creditors. Under such circumstances, the filing of the writ petition, taking that it is the government property, no more arise. It doesn't arise.
Before 2 points, of course, I am supposed to give a rejoinder, but immediate clarification I need to give. One, that with regard to, it's a question of title, transfer of title from one party to another. That cannot be the subject matter before the NCLT, and that has been decided in a case Gloucester Limited.
Correct. That you have to challenge.
Absolutely. So that I cannot go to NCLT because NCLT doesn't have jurisdiction to go into that. There is specific judgment to that effect exactly on that point by Gloucester, para 37. If your lordship would permit me, I will place it on record. Saying that these are certain issues which NCLT cannot go into. NCLT can go into only in respect of issues arising out of the NCLT Act. And not I can pass on this judgment if your lordship would permit.
That the NCLT being a statutory creature has its own limitation, and therefore the issues that are being debated before this court in PIL jurisdiction do not fall into the precincts of NCLT.
That judgment not and forwarded para.
In support of that, he places reliance on a decision of Apex 14.
Para 37.
Gloucester Limited versus Gloucester Cables Limited. What is the 2026 INAC 81? Paragraph
37.
Okay.
It's a
Next
question
point.
of title of trademark. My second point is there is a correction. I went through again that collector's letter.
Yeah.
Actually, it is 581 acres of land. It's not 336. In fact, government had acquired that land, had given to BILT. So therefore, it cannot be said that BILT had acquired this land on its own. So there is a mistake. In fact, ROR has explains in page 74 all the specific khasra numbers. So therefore, there could be an error. I wanted to point out.
Only thing I will point out. Well, so the NCLT, the resolution plan has been approved by the NCLT, and after matters being confirmed, we have deposited total amount 700 crores, 400 crores, 300 matters kind of
that split up is for the creditors, your creditor. How? That money is to be paid to the creditor.
All that money will be given to the creditors.
They are not saying all that. They are saying only thing. Well, this property, which the company not have been sold to it by regular sale, as if one private citizen sells it to another. Different considerations figure. This is contention. That's all. Though he is so much, we don't say time is wasted. Invested, we can say.
To that matters my specific answer is that at the time it was allotted to the built, necessary care has been taken so far that the person who has quoted highest at the negotiated lowest has been and thereafter matters it has become the property of the company.
Next.
We have not filed any counter in this case.
No, I don't.
Yes. One preliminary counter affidavit was filed by the affidavit party number 6.
Yeah. Why did you go for regular sale deed instead of the
Lease
auction?
Auction or lease, whatever. Lease was there earlier.
It was already there.
The lease were there.
Already there.
Here the limited prayer of the petitioner is to quash MOU dated 2024-1991 and to quash this sale deed
1994.
91.
Sale deed is 94.
Sale deed was 5/1/1990 and to quash it. Two prayers he has got. My lord, so far as MOU is concerned, we have got nothing to say. So far as registered sale deed is concerned, it was made after threadbare discussion with the cabinet, what Mr. Mahapatra said, and the governor has made a deed to that effect, sale deed to that effect. They have given copy. I had also verified it.
Where is the discussion as to why we should go for regular sale deed?
That is not. That discussion is not a part of my record or also. It is not there with me, but
that's the only case, sir.
Yeah.
All
That-
story, rest
yes,
of the
that-
stories.
That's why I'm cutting it short, my lord. So that I cannot answer because counter is not there in the absence. The counter which is there, my lord, preliminary counter, it is not. They have not discussed all these things.
Learned EGM Mr. G, when specifically asked as to why the mode of going for regular sale deed, as if it was between two private parties, instead of the public mode of public largesse, state largesse was adopted, very fairly submits that in that connection, much material is not placed on record. Yes.
That's much, my lord. I will not.
Anything more want to say?
No.
Behura
In the
was
absence
saying
of-
something to you.
This is very close friend of mine, man.
Minors only I will point out first because I don't have the detailed record particulars, but I will point out 3-4 things. Minors, the discussions, prior discussions were going on.
No, that we are not on all that at all. We want to know, it's a huge property. Why this huge property, the government decided to give this to company by ordinary sale deed?
By way of a cell.
That's what.
Yes.
That's we are asking you. Because what Apex Court said in the Tata Cellular
Yes.
judgment, Tata Cellular
Tata
judgment.
Cellular.
No. Tata Cellular says, whenever you want, of course, it came long after this transaction took place. But that Raman Dayaram Shetty was there already. R.D. Shetty was already there. If government wants to sell any property, it should go for public auction, unless it records reasons why public auction we cannot go for, and we will go for other modes.
Minors, only one, I mean, permitted to add only one.
Yeah.
Here in this case, it was a reference from BIFR. After BIFR, government required different companies to react, whether they are interested for or not. 4 came, 2 withdrew in the meanwhile.
Now, how 4 came?
Yes.
That we want to know. Why only 4? We have 100,
But
after those time, maybe around 100 crores we were.
But kindly visualize one thing. It was of the year 1992.
Therefore, we said that.
1992, minors, the companies, those who were dealing with that, minors, paper and all these things, very limited.
No.
Very limited. How much to that extent minors wanted to know the decision minors so far concerned. They are minors. I have already read the committee meeting was headed by the Chief Minister.
You said that. You do
Chief
not
Minister.
repeat it.
And
You remember everything.
consequential communications for negotiation also in Annex E by 10.
Why negotiation? That gives some doubt.
No.
Maybe there is something has happened. That gives an impression that way. No, I am not saying we are getting that impression. That impression can be
Your
raised.
mind may take up that,
Yeah.
but that has been dealt with.
This is number 1. Number 2.
Why negotiation?
Number 2. Suppose we approve this. We are not saying that we are approving, we are allowing, not allowing, rejecting. Nothing we are saying. We are treating a particular subject. Is it not? And Orissa is a growing state now.
Yes.
It's one of the growing states in the country. If public property is to be disposed of as if it is the chief minister's property, because decision is taken by the chief minister
No.
and the committee headed by chief minister,
High level committee.
high level committee headed by the chief minister. What public property will be saved at the hands of those people?
It's a very $1 million
They
question.
are first. It's all public property.
That is first, what Myler says, I understood. That is a $1 million question. Myler, I am not entering into that.
Some
I'm not entering into
not
that.
dollars at all. Amount. Other things I do not know what all has.
I'm not on that.
Dollars, if it has happened, we do not know.
I'm
Here
not
it's
there
a mix of only rupees.
Only I'm to point out one thing, whatever I read now from the MOU. MOU clarified the things. What Myler said, MOU clarified the why bill was given, why not others?
No, not on that. Not only four entities were there,
4 entities,
including. We
that.
are asking why only 4? Such a huge country, such a big population.
Yes,
We do not know who all would have come, who would have given more money, so that the people of the country, the state would have become richer.
May I submit one thing only? In 1992, when I came here first to do practice in 1992, I had been to that area. These areas were not so much developed.
No, that area is not the question. Whether globally any notice was there, why other inputs could not have.
All the details, that is not with us. But only thing one I can point out, they have chosen me because I opted less relief in comparison to others.
That was in respect of
Other demands, minors.
stamp duty.
No, minors, That kind of visualize one
That
thing.
last paragraph you already.
No,
The government considered
Yes.
that your demand was comparatively lesser than those of others, other three.
Yes, madam.
What is that?
But that is
The point is, they are not collateral benefit.
Madam, that is their manners. 1 and 2 later also, what are the negotiation terms? Madam, whatever document were there, madam, we relied upon that. Madam, kindly have class 2.
Our question is totally different.
What my lord say, why government has gone limiting this offer to 4 persons? Why not in a public tender?
Correct.
Why not in a global tender?
Yes.
That is what is the thing.
That's
But to that extent, so far negotiation part is concerned. That is not there with me, my lords. A right or wrong, my lords, title passed.
The rest of the things let us.
So far as the communications are there, my lords, they are the negotiation for various reasons. That is Annexure B by 10,
Yeah.
Annexure page 52.
Next.
Item 18.
Item 18.
Yes.
Last of the director, instead of the secretary UPSC, lodging director the deponent to appear in person.
We are grateful for the time during
It's order dated 27/1/2016. Director the Indra Malik, ex special secretary to appear in person. I am appearing and filing my affidavit that the recruitment, the post of dental surgeon, neither the deponent dealt with nor filed interested. The wrongly, my lord, wrongly, last occasion the secretary appeared and my name was given, and I am residing in remote area in the Fulwani, 250 kilometers.
What the secretary says now?
He is a retired person, my lord.
Retired.
Retired, and retired, he never dealt or interested the file.
Never.
Never. Your lordship, I have given the order.
I can say on the other day, the present secretary supplied the name at the relevant point of time. He was the secretary, he was dealing with the file.
Well, sir, I went through the file that day.
No, secretary did not suggest. We asked the secretary.
Yes.
Who were the persons who dealt with this aspect? He did not say on his own.
No.
We requested.
Yes.
You
ma'am.
tell the names and etc.
Yes.
That is dealt with by my Kushta Chandra Patri, the then secretary, and
Only.
para 4 and 5 of my affidavit, your lordship kindly see.
This matter. Because the candidates had raised some objection and you had sought for clarifications, you had appointed a committee for revaluation of the papers. During that period, why did you send the selection? Why did you finalize the select list and send it to the government for issuance of the appointment orders? That was the issue.
Yes, ma'am.
Which secretary had said that?
That secretary is Prasad Pati, not the present deponent.
Well, in fact, both persons have dealt different files, is what has come out. Your lordships may kindly have the memo that I've just filed. Mr. Malik has dealt with the legal aspect. The recruitment aspect has been dealt with by the then secretary, Mr. Patti.
What Malik said on legal aspect?
On the legal aspect, the writ petition was complied with, and the answer keys were provided to the petitioner. But your lordships may kindly first see page 1. Page 1 is a resolution number 5395 dated 3rd of September 2016. Therefore, much. May I read, my lords? Whereas a composite press note regarding mode of filing of online application and supply of examination.
Where are you reading all this? This will go only reading only. What's the point you want to make?
Well, the point here is there is a resolution of the OPSC which says that you as per UPSC's norms, the answer keys will be published only after publication of results. The answer keys will be published only after publication of the results.
Results means?
The results of after
examination.
The select list is published. After I publish the select list of names of candidates, only after that I will publish the answer.
That is not correct. That is not correct. Because of the judgment attached filed by my learned friend along with the memo, your lordship may kindly have a glance to the judgment.
Well,
No.
it is my memo. Let me
No.
submit my memo.
In your memo, you are not.
Let me submit my memo.
You are not furnishing the correct information to the court.
No, if
I am pointing out.
Goes correct from before us was that the name was recommended. Name of 4 persons were recommended while the court was in session over the matter, and it was not that.
Yes, ma'am.
That was all.
Well, it's on 6th of August, your lordships passed an order that the respondent be provided with the answer key if he makes an application to the OPSC. He makes an application on 13th of August, and we supply the information on 20th of August.
When this final list went to the government?
The final list has gone to the government on 18th of August.
That we are asking.
It has gone on 18th of August.
Why it went to on 18th?
Well,
when everything is being looked into.
Well, it's because of page 1. It's because of page 1, ma'am.
Page 1?
Yes, ma'am.
That UPSC procedure.
The procedure that is adopted, the standard procedure that is adopted, is that only after publication of results, I will provide the answer key. And there was no legal injunction from this honorable court that the results may not be published, that the select list may not be published.
No, select list cannot be sent. Suppose after the revaluation, now the candidates have secured more marks, less marks, etc. It undergoes change. Is it not? Then what are you going to do?
Once a select list is published, it is deemed to be a final select list.
No, therefore we are asking you, why did you publish the final list at all?
Well, it's because there was no impediment.
You had taken a decision to go for the valuation at the hands of experts.
No, that report has come in October.
Which report? No, you took a decision. On which date you took the decision?
Well, it's that we were trying to locate in the file. That document we were not able to find out. The report is dated the second expert.
When you took the decision to send these papers.
Well, it is only after these things that happened. Well, let me just clarify the timeline again. On 6th of August, your lordships passed an order that if Dr. Sanjay Kumar Panda makes an application, the answer key may be provided to him. Till now, nobody knows. There is no public knowledge regarding the correctness or otherwise of the answer key. As per us, the answer key was correct. On 9th of August, accordingly, we published the select list. Thereafter, on 13th of August, Dr. Sanjay Kumar Panda made his application to OPSC and provided us with a certified copy of the order.
Order of the court was when?
6th of August.
6th of August.
Yes, my lord. We received a certified copy of the order on 13th of August, along with an application petition by Dr. Sanjay Kumar Panda. I have annexed that application, my lords. The order is at page number 2. And if your lordships may have the relevant part at page number 5 bottom. Your lordships have the last 4 lines. Since the examination was over on 6/5/2018 and the petitioner filed an application under the RTI Act to obtain the answer key and mark sheet on 25th of June, we direct the OPSC to supply the answer key and mark sheet to the petitioner on or before 20th August on filing proper application before the OPSC by the petitioner. Now, this application
he filed on 13/8.
On 13/8, that your lordships will find it serial at page number 8.
And you took decision on which date to send for
that we were not able to locate, but the report is dated 15th of October. That is the second report of the experts committee.
Where is that report? Whether first report was also there?
Well, that is there in the or that is recorded in the order of this honorable court. That report is not part of the record.
No, we want to look into. You were asked to keep all the papers ready that day.
If your lordships have my convenience compilation, page number 20, this is order dated 15th of November 2021, passed in WPC OSC number 2542 of 2018. Page 20 of my convenience compilation.
Page 20.
Yes, ma'am.
Anyway, we'll come to that. Now this person is retired. He has retired.
My lord.
And he says, I do not have much role into that.
My lord.
But what is the legal role he played in that matter?
Well, if your lordships have page number 9 of my memo.
Only one. Only I am adding one because the fact has not been properly placed.
Because I have an objection.
No,
We finish, then
you are publishing incorrect.
I am the appellant.
Down, we'll come back to you.
Yes.
Yes, we'll come back to you.
Okay.
Page 9, if your lordship sees, of my memo, the communication of the answer key to Dr. Sanjay Kumar Panda was made by the Mr. Malik.
Malik is previous secretary.
Yes, Malik. He was the special secretary. Back then, special secretary was the head of the department.
Ask where is he? Where is that Malik? Yes, Mr. Understand English? Yes, come please.
Second item.
What was your role in the recruitment process?
I have not been assigned with the recruitment process, sir. As well that has been assigned by virtue of order of the chairman to the leader secretary. I was then special secretary.
You were special secretary.
Sir.
What did you do?
I was the director of bill project.
You were the sum of the papers, they were signatures.
Yes, sir, that was done, sir, because they have under the file for forwarding of letters only. Sir. And then the process was maintained by the secretary and assistant controller of examination and DR 1 to 4 session, as well as the confidential 1 and 2 system. And
Can you, from your papers, what was the role he played in this?
Well, he has sent page number 9. Page number 9 of the memo.
What is this?
This is the communication on 20th of August in respect of the writ petition filed by the respondent. We say that we are giving you the answer key. The answer key is being communicated to Dr. Sanjay Kumar Panda.
That's the only thing coming out from your record.
Yes, Malik.
Huh?
And the communication of the list of selected candidates to the government, that was made by one Mr. KP Patti.
KP Patti.
Yes.
Not with by this person.
He was the...
That was sent on which date?
That was sent on 18th of August 2018.
18/8.
Yes.
But then
18 months.
18. You are not able to tell when the commission took the decision to go for the valuation.
It was re-evaluation that was only thereafter. If your lordships have paragraph 5 of that order of 15th of November 2021.
Which directed furnishing of key answers and other things.
Which this order directed OPSC to implement the second expert committee report. That is...
Second expert committee report.
Yes, Manoj. That is dated 5th. Your lordships may kindly have page 20 of my convenience compilation.
20?
Yes,
convenience compilation.
Page 20 of my convenience compilation.
No, brother, we don't interfere in this matter. Because you only had told the government that the other persons, how many persons?
11 months.
11 persons
11
can be issued, of course, not these people.
Yes, ma'am.
But you had specifically stated, for 11 persons, you can issue the appointment.
Yes, ma'am.
We remember.
Now, what the learned single judge holds is that the Odisha Public Service Commission does not have any jurisdiction to change the cutoff marks.
No, that may not be correct. That will be lacuna in the order.
Yes,
But, it will not go to the sustainability of the order.
well, it's what has now transpired is, as per the first select list, 11 candidates who are not deserving, I am calling them undeserving candidates,
Whom you had recommended for issuance.
whom
of
we recommended. OPSC has committed a mistake, but we recommended them. And they are in appointment. They are, even today, they are serving. When these issues regarding reevaluation came up, finally, we found that these 11 undeserving persons, because they're already in service for so long, we took a decision not to disturb them. But
You means who are you?
OPSC,
How OPSC is that? This, you will recommend to appoint or not to appoint. It's over. End of the matter.
well, we advise the state government. We advise the state government that there will be several litigations, therefore not to disturb the 11. But however, in order to ensure that 11 deserving candidates who did not get appointment, to bring them into the sphere of appointment, we recommended that
These respondents.
these respondents are below the 11 new deserving candidates.
They are, in the first list, they were above.
Absolutely
No, but-
incorrect fact, Funny.
1 second. We are asking you. In the first list, whether they were above these 11 people or below 11 people?
Below.
In the second list,
In the second list,
they
they are
became
below
above. They became more meritorious than the selected candidates.
they are more undeserving selected candidates, but they are not as meritorious as the deserving candidates who were selected later on. Therefore, Malats, the claim of the respondents today is based on the mistake committed by the OPSC, which is recommending 11 undeserving candidates. Therefore, your lordship knows the principle of negative
No,
equality.
principle all right. But all these things are happening in OPSC means it is not simple thing. It can happen only for Vyavahar. Otherwise, how it will happen? There appears to be, I don't say we are auctioning these things, but some deal it gives an impression that things are not that.
Because actually, the genesis of the problem is when experts go wrong.
If it is innocent wrong, we would not have much bothered. There appears to be some vyapar. Otherwise, it cannot happen.
Today, because we have to depend on academia to fix the question papers. The members and chairman or any officer of the OPSC, experts in the field of dentistry, in the field of civil services. So therefore, they employ members from the academia, from various universities. Now, very often, if these
Working now.
No,
Not yet issue.
we have not finished.
Not yet issue.
No.
Learned single judge said what?
Learned single judge directed for appointment.
learned single judge directed it on the basis that I cannot change the cutoff marks.
No, that is not the only.
Yes.
That is not.
With the
Provisions. The judgment starts at page 171.
171, the relevant starts at 206.
206. Internal page,
Page 34.
para 9, 10.
Well, it's internal page 34 of the judgment.
34.
206 of the brief.
No, not 34.
Para 46 onwards. In fact, it starts from 43 onwards.
Judgment. Improved judgment.
Para 32, page 196. Internal page 24.
But fact remains, those 11 who have been issued appointment letter, they are less meritorious than the respondents.
My lords, I bow down.
And that it happened because of the mistake of your client.
I bow down, my lords. sort of said that mistakes cannot be allowed to be repeated.
No, don't repeat it, but let it be like this. For next repeat means you cannot repeat it in the next recruitment process.
Now the respondent, today the respondents seek parity on the basis of undeserving
Not
candidates.
parity. The same advertisement, same selection process, I scored more marks. I have not been appointed, whereas 11 candidates securing less marks, they have been appointed.
If only
It is
the
prior to the scrutiny or after the scrutiny?
Before the scrutiny and after the scrutiny, they are 11. Before the scrutiny, it was 8. After the scrutiny, it became 11. They disclose now, it is 11.
before the scrutiny,
In the writ appeal, they say it is 11. But before the Honorable Single Judge, they filed an affidavit, only 8 candidates have been securing less mark than the petitioner have been appointed. Therefore, the Learned Single Judge, Honorable Single Judge directly asked the Learned Counsel appearing for the parties, in the same selection process, someone secured, according to you, 189 point so and so mark, and someone secured 184, he has been given appointment. How can it be possible? They could not give any reply.
Been dismissed, broadly agreeing with the reasoning of the Learned Single Judge, where he says cutoff range would not be changeable.
Personal appearance will distance me.
Another order of the
Well,
personal appearance of Secretary, the then Additional Secretary, Mr. Chandra Malik, Umuda Chandra Malik is noted, and he has filed the affidavit mentioning what limited role he had in the matter. First off, we have also known his counsel submission that he has already limited office on attaining the age of superannuation in the year
28 to 21.
with effect from 28 to 2021. And therefore, much digging in the grave may not be undertaken. First off, we agree. And he said, yes.
well, may I place one judgment on negative equality balance? One judgment.
That's true. But question is, in the writ court is a court of English court of equity.
Malad.
Perhaps little more than that. Equity. Of Ramantaram Shetty versus International Airport Authority. Entire law they decided in favor of the petitioner. But relief they did not give because it's a court of equity, they say. Lost one paragraph, small paragraph.
Well, it's because if the respondents had impleaded those 11 undeserving candidates,
You should have stated why they should impede. You should have stated that from our side mistake happened. We should not have asked the government to issue appointment letters to these 11 people. That mesmerizes me. It bewilders us actually, not mesmerizing. It bewilders us. It cannot happen without Vyapar. Say the least.
we have stated
Who are all the bounty sharers we don't know. But these things, saying that recommending to the government, yes, issue appointment orders to them. They are less meritorious than these people and much less meritorious than the meritorious people, otherwise meritorious people.
yes,
What else is necessary to say we will not exercise our writ jurisdiction in your favor? That single judge has given his reason because of the conduct also. Conduct also. Yes.
grateful.
Thank you. Item 2.
Kindly pass over, one pass over.
All up to 2. Next.
Item 3,
May I argue, my lord?
Yes.
Has to be special.
Huh? Which matter? Brother, we are nearing 3 now. No passover up to 3.
No, my this is mine.
Your?
Yeah.
Huh?
Item number 2 is yours.
My
Tell.
lord.
Whole day, one matter we have heard today. Yeah.
Item 2. Item 2, my lord. The petitioner challenging in the order dated.
Make use of the mic. Be loud.
The petitioner challenging the order dated 30/10/2000
All right, what is that order?
under Annex 5 Mylar. Filed the 14 SARFAESI Act Mylar. The collector passed an order under Section 14 of the SARFAESI Act Mylar. In the meantime, my OTS proposal now under Annex 2 Mylar. In the meantime, I have given out of 2,75,000.
What is the amount due?
I have availed the loan of 1 lakh.
1 lakh.
Young man.
When it was?
My repentance.
Total amount paid is 2,71,020.
Yes, madam.
As on?
As on
21/9/2024. It will be. Is it housing loan?
Yes, ma'am. I have deposited in the meantime. I have deposited 40 lakhs, my lord.
40 lakhs?
Yes, ma'am.
For one?
Sorry, 40,000, ma'am.
Yes.
My proposal is pending, my lord.
You propose to pay 40,000.
No. I have already
deposited.
Already deposited.
40,000
In
you
my-
have deposited?
Yes, ma'am.
When?
Kindly see the my.
No.
When did you deposit? 40,000 you have deposited after this possession notice?
Yes, my lord.
Are you sure?
Annex 2, my lord. Kindly see the Annex 2. In the
Annex 2 is your representation.
Yes,
when
ma'am.
did you deposit that? You have proposed, you have said, निबंधन में 40,000 दाखल करी that you will deposit.
Deposit.
Yeah.
He is
When
saying
did
that
you
you have
deposit?
deposited.
Date not mentioned.
That-
You have deposited?
Yes, ma'am.
You have simply said that we will deposit.
Yes.
When did you deposit? After this, did you deposit?
You pay 50% of the amount in demand now.
50.
You 2 weeks. 50% you deposit. Then let the bank come and let us see.
20.
No, we cannot bargain
house
that way,
loan,
like
man.
vegetable vendors.
Small amount, my lord.
Therefore, you should pay 50% of that. It will be still smaller. That's how. Issue emergent notice. Status quo in state of hearing in terms of application in IN number so submitted by first one. Counsel for the petitioner borrower submits that it was a housing loan and that his client has remitted a sum of ₹40,000 post issuance of section 14 notice. First one. He also agrees to deposit some reasonable amount to show his bona fide. Tester. In the above circumstances, application is disposed of. Parties to maintain status quo in respect of the security property. Any encumbrance or alienation subject to petitioner depositing with the bank, crediting with the bank 50% of the amount. It will be how much it is. The bank should not say much more. It will not refer to like 71. Last year. 1.5. 1.5 like 75,000 and 75,000.
Yes.
That way.
Yes.
Subject to petitioner depositing rupees 1,50,000 in 2 equalized fortnightly installments. Reckoned from the first reckoned from today, failing which not only interim order stands rescinded, but the petition runs risk of dismissal on that. Okay. Next.
Item 3.
Housing loan. Loan amount is also small at that. Also small. Petitioner appears to be full. Yes.
My lord, kindly answer.
After 2 weeks at the request of. Yes.
Item 4.
I am a pleasure lordships. My sole prayer in this writ application before a lordship is to accept my deposit. Mirrors, what has happened? Mirrors, after getting the loan, house building loan of 13 lakhs, mirrors, I have been regularly paying up to August 2025 or 8 2025 minutes. Thereafter, mirrors, I am a practicing lawyer in District Bar Association of Jagatsinghpur.
The law relating to loans
Does
does not differentiate between a practicing lawyer, a sitting judge.
minors.
Everybody is bound.
But yes, madam. But
What was the amount borrowed?
amount is 13 lakhs only.
30 lakhs. When did you borrow that?
In 2022 minutes.
What for?
For building the house loan, minors.
Housing loan.
Minors.
What is the amount due now?
Now due as per your lordship may kindly see that is pair to 17. Yes, minutes.
What is due means what is
Yes.
Turning the pages will not be.
Minors.
What is the amount?
Till December, due is only 9,352.
9,000.
Yes, only.
Only 9,000.
Yes, minutes.
Is it true?
Yes, there is that
Right,
bank
back or 9,000?
bank statement, 9,000. Minutes. It is statement of the bank
Just
statement.
how much money is due, Mr. Bank lawyer?
As on today, due is more than 40 lakhs.
More than 40 lakhs?
40 lakhs and the possession notice says 14 lakh 48,842.
Yeah. 40 or 14? 14.
Lakhs 48,008.
He will 7.5 lakh. Now he will deposit.
And already auction sale has been confirmed. Now, under SARFAESI Act and statutory remedy under section 17 is there.
Yeah, you go before the DRT.
DRT.
When confirmation happened?
Confirmation.
There's nothing in fact has happened.
Just now I have
No.
received the
No.
message.
No, there's nothing, no single notice. But I have printed everything.
Notice, we are not.
Without notice bank.
No.
No, when it happened? When it happened? He is a liar.
Yes, I know.
Do you know the Shakespeare said, "Let us kill all liars."
Not
Yeah.
on 28/1/26, sale has been confirmed.
28, 1,
26.
26 in January 2020.
And he has to file the appeal under section 17.
that he will do, but this 28, 1, 26,
Yes.
then appeal will be in time.
Yes, sir.
Appeal will be in time then. Okay.
Yes.
Let him file appeal immediately.
My lords, so what has happened was no notice. My lords, I have within my
Take up that contention. You take up that contention. All contentions you take.
Each and every.
Petitioner, borrower, a professional,
Judicial is
a practicing lawyer is knocking at the doors of the court, grieving against the coercive action of recovery being effected by the lending agency under the provisions of the SARFAESI Act 2002. First, learned counsel for the petitioner vehemently argues that the private property is the only property for the residential purpose of his client, and right to reside being expansively interpreted by the apex court, putting to retain the residential house in accordance with law. First, he tells us that the bank is not justified in effecting the recovery proceedings under the provisions of the Act without complying with the restrictive covenants. Therefore, he seeks relief at the hands of this court. Per contrast, alternate panel counsel appearing for the bank resist the petition, saying that already the property having been, security property having been auctioned on 28/1/2020, the only remedy available to the petitioner is to file an appeal under section 17 of the Act, and that there is still limitation period therefore. First, we agree with this. Next, in the above circumstances, petitioner is relegated to the appellate remedy, keeping open all contention. Ordered accordingly, petition is disposed.
May I submit only one thing?
We don't interfere because we have apex court. You have seen that. Yes, next.
Item 5.
Wafna. Yes.
May I please, your lordship? Item number 5, I am for the petition, my lord. Lord, out of 74,000 and something odd of housing loan, I've taken
74,000.
74 lakhs. Sorry.
But nobody is differentiating between 1,000 and lakhs.
Pardon me.
Yeah.
Out of 74 lakhs.
As on today, what is the amount due?
As on today, it's 22 lakh something odd, my lord. It's
22 lakh?
Yes, my lord.
As on which date it was?
It was but up to 2025, my lord.
Up to 2025?
25.
Yes. Now what is the position? Property with whom is whom?
Your lordship, it has already been auctioned for sale.
Yes.
I just want to, it's my humble prayer, your lordship, that that person is very honest and he's doing
very honest.
He's doing his business.
Therefore, he does not. His principle is that he will not pay the interest.
Actually,
and
due
paying
to
principal back is not in his interest.
Actually, he has already paid 75% of that amount, your lordship.
No auction has happened. Auctioning of the property happened.
No, my lord.
Now, what is the position of the property? With whom it is lying?
It is lying with him only. But the situation is that still, after paying 75% of the loan amount, only 25% is due.
Sale notice is there.
Yes, your lordship.
Sale took place.
No, your lordship.
Then
I am praying only for extra time so that he can arrange money from other sources, because he's facing losses due to the disturbances in the Middle East, because he's doing businesses in shipment. And he has already uploaded the items, but due to disturbance in the Middle East, it has been ordered to stop those ships.
As on 15th of December 2025, you are due to pay 29,92,000.
Exactly, your lordship.
Where are your bills?
That is accumulated due to the interest and other amounts. It's accumulated at 29 lakhs. But
exactly shipment is in transit now.
Yes, your lordship.
Where are the bills of lading?
Actually, I have not annexed that portion, but I have
show us that you have already shipment has been done. Ship is she is on the sea.
Yes, my lord. But I have not annexed that document, but I have annexed the financial statement bank provided.
Who appears for the bank?
Pardon, my lord, I have instruction to appear for the bank. Your lordship, let them serve a copy of the.
So now what you are going to do with the property?
No, I don't know exactly which property subject. But
no, let him pay 50% of the amount in 2 installments. In the meanwhile, ship will come and he will unload the goods and give the money.
Your lordship, you will arrange the money from other sources. I just need some extra time, your lordship. If your lordship kindly.
How much time?
If 3 months, your lordship. Because
81-year-old that ship permanently in the Irish Sea.
No, your lordship, his family members and his 91-year-old father is.
50% you pay.
My lord,
2 weeks.
My lord, he is ready to pay all the amount at one stake.
Now you show
only time I need, your lordship.
You had made the same statement to the manager when you wanted the loan. Now you want the order at our hands and therefore you are making the same.
Sir, he has already paid more than 75%, your lordship.
Therefore, 50% amount you
my lord, he is ready to pay at one stake, but only humble request with folded hand.
No, fold any your hands at all.
Only time I want, your lordship.
Issue.
At least 3 months, your lordship. At least 3 months.
Learned counsel for the petitioner draws attention of the court to IN number so court declare affidavit seeking interim protection at the hands of the court. First up, he submits that he is claimed to being a businessman. He is in the middle, has been residing in the Middle East, and that his business is being affected because of some turbulence in the business. First up, he also repeatedly tells us that if 3 months, a period of 3 months is granted, entire loan amount would be remitted back with the interest accruing due thereon. First up. Next one, learned panel counsel appearing for the bank vehemently opposes grant of any interim protection, contending that petitioner is not a scrupulous borrower and therefore is not entitled to any such protection. First up, next, having heard learned counsel for the parties and having perused the appeal petition papers, we are of the considered view that some interim protection can be granted in as much as petitioner has already remitted about a large chunk of, already remitted back a large chunk of the loan with interest accruing due, and that there is no reason to think that he would not be, doubt him that his client would pay back the remaining amount if extension is granted. First, however, in the meanwhile, protection needs to be afforded, subject to condition. First, in the above circumstances, application having been favored, the bank is restrained from taking any coercive action of recovery if petitioner pays 50% of the amount due in two equalized fortnightly payments, the first reckoning from this day. Failing which, not only interim order stands rescinded, but petition runs the risk of dismissal on that ground itself. Yes.
Grateful.
Item 6.
May please, Your Lordship.
Yes, sir.
My Lord, petitioner challenging entire proceeding which is not issued by the opposite party number bank.
Entire proceeding means what all?
My Lord, Your Lordship, kindly see.
But the stage no 13-4.
Already sold out the property.
Then go before the DRT.
Petitioner went to DRT. SA is pending before the DRT, but in DRT, what is happening, my Lord, Justice, because of all entire community are, even if sometimes that issuing notices
to do.
My Lord, Your Lordship, kindly for a moment just see kindly page 4.
No, your essay is pending.
Essay is pending but did not grant any interim order. Then petitioner invoke rejurisdiction before this honorable court. My Lord,
What is the amount due?
amount due is, my Lord, 2 loans club by the opposite part number bank. That is 49,90,732, my Lord. In fact, it was 34 lakhs.
No, that goes on increasing now if you do not pay.
2 loans club. 1 loan was regular basis. We are
Now,
paying
totally how much amount is?
as on date, they have initiated 49,90,732.
Around 50 lakh. You pay 50%. Now what happened? What is the status now?
My Lord, this matter is entirely, it is seized up to the DRT under section 17. They have filed the separation application.
I am not denying.
And I am appearing on behalf of the bank there. Tomorrow is the matter fixed for IA hearing.
We will direct
And
DRT.
this is the order passed by DRT.
Now tomorrow it is posted.
Yes.
Order I have annexed, my Lord, Your Lordship, kindly see.
Anyway,
I have not
that is
suppressed
old order.
My Lord,
This order is the latest order.
my Lord, latest order also I have
Tomorrow
annexed.
matter is being.
Tomorrow we are going to file the reply and matter will be heard tomorrow.
Till then, don't
My
take
Lord.
any. When that application was served on you.
Sir, this is not served to me. Writ
No,
petition is not
application.
served.
My Lord,
Application also not served to me.
May
Only IA was
your
served.
apology, may I permit to only submit only one sentence.
In this matter,
My Lord, many tumors are coming in DRT, my Lord. Not only myself.
That is not-
Entire advocates communities are suffering, my Lord.
said that.
My Lord and President is sitting here, my Lord.
Yeah. What he should do? Should he run away? Why sit here because he has a case next?
He's our guardian, my Lord.
My lord, in that case, there is alternate remedy
Because of the
for
entire
TR-80.
He
They can approach appellate tribunal.
seeks to call in question the coercive proceedings of recovery under the provisions of 2002, SARFAESI Act 2002. First off, learned counsel for the petitioner.
My Lord, in the meantime, they can sell out the property, my Lord.
So and so.
Property is also sold already.
DRT.
Right.
And the TRT not taking the matter. First, he also tells us that not only in this matter, but in many other such cases, matters are not being treated even when applications for interim protections are moved. First, per contra, learned panel counsel appearing for the bank submitted that the writ jurisdiction cannot be invoked in matters like this. Semicolon. The subject property is already auctioned
Already auction, my lord, on 28th.
on 28/1.
Yes,
But
January.
don't confirm the auction.
Confirmation is also done.
Why?
The
Within what period?
same day confirmation has to be issued.
Which is the where is the there is no confirmation
That 25% once the bidder pays,
Yes.
by next day,
Yes.
confirmation letter has to be issued.
No.
This is the intimation come
That's
confirmation.
intimation, your bank's intimation.
Inter-mala-fide intention committed by the bank, my lord. Sorry, my
You
lord.
want to lose your peace?
No, sorry, my lord.
Because we are losing our temper now.
My lord.
Yeah. Brother, 25%
Your
will be
lordship.
deposited as on the date of the auction or within particular period.
Yes, your lord.
For remainder, time will be given to him to make the deposit.
That-
And thereafter confirmation arises.
No, my lord. The rule says the auction will be confirmed in favor of the H1 bidder the moment 25.
So sales
Then
certificate
fair
has-
certificate will be issued.
Don't issue sale certificate. Don't issue. Otherwise, what benefit he will have by going to the DRT? And DRT does not pass any interim or relief at all. Every day matters are coming like this.
That apprehension,
That
of course,
apprehension is new,
I
because you have been
don't
seeing.
support that. Even sometimes DRT passes orders also on merit of each case. So this case, when I submitted that this was already sold,
All right.
he had said you file reply, we will consider on 10th.
All right, till that application is considered, don't issue sale certificate.
Obliged, my lord.
What you written?
My lord, this order might,
And that the auction has been confirmed on 28/1/2026, since the auctioneer has remitted 25% the amount, auction amount. First off, be that as it may. Next one, having heard the counsel for the parties and having perused the appeal papers, we are of the considered view that no useful purpose will be served by keeping this matter pending. When the essay, the application moved in essay, pending essay number
8th of 2026.
26 is being taken up for consideration tomorrow. First off, all contentions of the parties are kept in mind. First off, the bank is directed not to issue sale certificate.
my lord, one submission on my side.
Till how you are concerned?
No, this may jeopardize the interest of as well. This order will surely, it will affect, prejudice the auction purchaser. So let auction.
Change in that person last name. The DRT is requested to hear and dispose of the pending application within 3 days. Application within 3 days.
Still then not to sell certificate may not be issued, my lord.
If the issue, if a sale certificate is issued, the same shall be subject to result of the application.
IA.
That's what.
Securitization application.
Huh?
Securitization application or the IA?
Application in the filed in the pending essay. Okay. That is
Obliged.
next.
Item 7.
May I please, Your Lordship? In this case, the petitioner has availed 3 housing loan and 2 top-up loan. The total outstanding dues was 37,48,000. This
Around,
also
about 38 lakh.
about 38 lakh as on 24/9/2025.
25.
Till passing of the interim order on 2nd February by the civil court, I have deposited 3,19,000. After that, 19,000. After that, thereafter, after passing
You
of
will ask
this,
to deposit 15% of the
15%. I have already deposited 17,49,000. I have submitted the account statement, my lord.
17 lakh.
17 lakh
50% of the
49,000.
amount.
50% of the amount.
50% of the amount. When did you deposit that?
I have on 4th February at phase 3 of my
Asking the date.
February, 5th February.
What February? Is it true, brother?
But by 5th has met the
You have deposited.
My lord.
You will deposit the remaining amount also. Your bank wants the money.
My lord,
Yeah.
the term loan is yet to be completed in 2013. My all payments is excess in terms of the sanction order, my lord. Installment fixed up to 2013. I have paid for regularization of that loan account. That
But can you consider now what amount he has paid in excess of what installment he has required to pay?
My lord, once the rule has been recalled, my lord, he will.
We will make some order in that. Under the shadow of that
My
order.
lord, I will take a very fair submission. My lord, as on 24th September 2025, the outstanding 8 lakhs. My lord, as on date, I've taken instruction that is more than 42 lakhs odd.
42.
More than 42 lakhs odd.
All.
My lord, if he makes the payment by February this month end, my lord, then on the date of 38 lakhs, whatever is balance, my lord, the bank is willing to consider and close the account.
The entire money.
No, not the entire money as per the section 14 order, not 42 lakhs.
14 order is how much?
37 lakhs, 48,000 odd. So approximately another 15 lakhs odd. If he makes this payment by February, the no penal interest, no further interest on from 24th September would be made applicable to him. In any event, he's getting
You make it 31st March.
well, 31st, well, he's
And interest also.
and interest also. As
31st March. Entire money should be paid. And if he does not pay, you go for.
Already what the difficulty?
You have said yes.
Yes, but my difficulty I'm saying. My entire residential house under lock of the bank. That is required.
You give that money, they will give back the money.
That is the difficulty. Well, number one, my gold ornaments, everything, my family properties and documents, everything inside the house. They lock the payment. It is required to be open. I have made more than.
Yeah. Now you permit him, you retain the property, you permit him to take whichever items he wants to take from the property. All movables. The movables are not part of the security property.
I believe so.
Is it not?
I believe so.
Yes. Therefore, you permit him to take whatever items he wants to take from the house. Tomorrow, what time you are going to bank? So, you said, no, ornaments and all things are there. Or you put something else also.
No, something else, documents, everything. They put the luck. That can be regularized. There is no bar for regularization.
And we will dispose of the matter, saying that on or before 31 March 2026, you should remit back entire money. You said yes. 2 minutes ago, you said yes.
Yes, because the client has no other option.
Therefore,
the regularization, it can. The account declared.
Challenge of recovery.
I have deposited.
First, why our order date, interim order dated
That 2026.
2026, we had said as under. Next paragraph. Learned counsel for the petitioner, borrower submit, and the learned panel counsel appearing for the bank does not dispute that in terms of the said order, above order, the petitioner has already remitted first of the two installments.
17,49,999.
That is rupees 17 lakh plus. And another installment of the like sum.
That is full two installments I paid. That is the confusion I want to clarify.
Okay,
that is the full 50% I paid with anxiety to reopen the house.
First, counsel for the petitioner further submit that if a time is extended till 31st March 2026, he is trying to be able to remit entire money back, failing which, let the bank take whatever action it wants to in accordance with law. First off. There is the first one. Next paragraph. Although the above submission is a bit opposed by the counsel for the now he very fairly agrees with us that during the lull period, the amount will carry interest and other charges. First one. With this proposal, counsel for the petitioner is also agreeable. Interest you have to pay for the remaining amount. It's a bank.
My friend saying of the 37 lakhs.
The above circumstances, this petition is disposed of the following direction. First, one, petitioner shall be permitted to take his movable articles from the subject house property mortgaged for securing the repayment of the loan. And the bank shall facilitate the same. Day after tomorrow.
Let him approach the bank for day after tomorrow.
No, we should fix that. Otherwise, again, they will trouble him.
As well.
Day after tomorrow, during 11 a.m. and 3 p.m. 3 p.m. First off, the entire exercise may be videographed. First off. Number two, petitioner is the period for repayment of the entire loan on or before 31/3/2026 with whatever interest accruing due thereon as per the terms of loan agreement. against. First of all, till then, no coercive proceeding shall be taken by the banks. First made easy. All right. Next.
My lord, I was only praying that because 31st March would be the last date.
But therefore, I fix it.
So that
The
is-
year end, financial year begins on 1/4.
Yes.
So end of the
Documentations.
this year we have
Documentations 10 days, my lord. That is what.
we cannot do. Look, this is a risk.
I bow
We have to do justice.
Mistake has to be completed only.
That people will lose faith in the institution.
I bow down.
The my lord, entire payment has to 31st March.
31st March. You can make some payment to us also.
No, we have already paid because
Yes.
we have already paid for that 50%.
But both pieces.
Next.
Item 8.
He said we have already paid. Everybody will be seeing our online. Yes.
Grant 1 week time. Some clarification I need from their agent.
10 days we grant. 10 days. Request.
I have a prayer.
Next.
I have a prayer.
Item 9.
Next week, man.
Yes, sir.
In that case, I
You
have
want
a
some short period, na?
yes.
Yes, all right.
Yes.
2014 matter.
Yes. Next.
Item 8 for next week.
Next week. Put it next week. Put 8th next week. The request. Next week we'll have. No.
Item 9.
Item 9, Mr. Padi has
Mr. Padi has to come in this matter. No, already he said, week after next.
9 and 13, Mr. Padi would be there. Same customs, all the two different petitioners, and the issues are more or less would be similar.
These are connected matters.
Not connected. No, not connected. The issue is the same, but they are not connected to each other.
When he will be able to come and
will be available day after tomorrow, but
No,
my
this
learned tenure will come from Delhi.
I come from Delhi, 27th of February, if possible, Your Lordship, Friday.
27th, no. 27th
27th of February.
We have some difficulty. Even the March 9th.
March 9th, Your
See your diary and tell.
Your Lordship.
Whichever date you suggest in March.
9 will Lordship, can it be 10th March? 10th March.
Yes.
9 and 13.
9 and 13 both, Your Lordship.
9 and 13 called together.
Pardon, my lords.
Yes.
My lords, only that last part that the bank may be permitted to proceed in case of failure. That will.
The event that is not
Item 7.
event. Payment is not which has an interpretation before this court. It is open to the bank to proceed with the coercive measures of recovery. Yes, next.
Item 10.
My lord, item 10, Lord and DSI out of station, my lord, he is sick 1 week time, my lord.
Up to 1 week. 1 week at the request of. Yes,
Item 11.
My lord,
same order. 5 matters he said, na?
pensioner benefits, my lord, that are not liquid. Short time may be given.
Item 12 and 13 have been adjourned. Item 14.
Item 10, my lord, may put it for a date, my lord.
Till 1 week we said, Mr.
When
Next week it will come.
11, my lord, next week, the pensioner benefit, my lord, the link.
Let us.
11.
Yes,
Item 14.
1 week tax will be given.
2 weeks. Next.
Item 15 has been adjourned. Item 16.
16. Yes.
Just before starting petition council and for the Kendra with the opposite party, then just recapitulate your lordship memory, that is the matter once heard by your lordship, that is conversation from CPF to GPF, all secondary documents filed before the tribunal, that she has continued, they are continued for 33 years on CPF, retired, all the benefits they have got and enjoyed. After 5 years of retirement, they that matter is heard in part, and you will also directed the petition council to file the written notice of argument. Now another batch of case, one judgment already delivered by the bench, your lordship, the coordinate bench already disposed of the matter. Where the confirm the order of the.
If my friend has no any difficulty, and I would like to place
Yes,
my case,
you place,
my lord,
you place, your lord.
because I have come with the
recapitulating your
latest
lordship.
judgments. These are decided by old judgments. No
This
new
is-
judgment has been considered, my lord,
Two
in
copies.
these cases.
I have given another.
This is 5/5/2025.
My lord.
Even then, my lord, no, in the Supreme Court as well as different High Court, affirmed up to Supreme Court has been considered. I will show, my lord, right now, my lord, before your lordship.
That has been considered.
No.
Which judgment is not considered?
My lord, I have annexed the Supreme Court latest judgment of 10/5/2022, that is University of Delhi versus Shashi Kiran and others, which has decided the issue in all the three batch of cases, my lord. By the Delhi High Court single judge, it was categorized in three batch of cases, my lord. First batch was R.N. Virmani.
10/5/22.
10/5/2022. I have annexed with my writ application, page number 30.
That judgment is not considered.
Not considered. Even
What
thereafter,
was the law laid down in that?
Judgment I have annexed with my writ petition, my lord, at page number 34 to 58 it is.
Which paragraph?
I will show, my lord. Let me summarize, my lord, your lordship, in a summary manner.
The matter already.
My lord.
Huh?
My lord.
We don't forget.
Then let, my lord, I have come to the Vijay Lakshmi Sharma case. I have annexed. Let me finish, sir.
We'll come to.
Let me finish. You will get the
We'll come
chance.
to you. We'll not pass any order.
Yes. Then, my lord, may come at page number 59. It is based on the, it is the writ filed by the Kendriya Vidyalaya Sangathan before the Rajasthan High Court. My lord may see page number 59, annexure 7. I would like to read, my lord, para 9 to 12. It will clarify everything. Para 9 to.
No, 1 second.
No.
You say
My lord.
10/5/2022 judgment is not looked into.
Yes.
Which is that judgment?
It is at paragraph 3. It is annexure 6.
University of Delhi versus Shashi Kiran and others.
Others. It is page number 30. Next is my writ application.
What is the relevant paragraph?
My lord, relevant paragraph is, my lord, paragraph 7 first, my lord, at page number. Reading page number 43. May I read, my lord?
Yes.
There were three batch created by the learned single judge before the Supreme Court. Then it went to the division bench of the Delhi High Court. Then it went to the Supreme Court. My lord, it has been discussed, my lord, what happened before the division bench before the learned single judge. My lord. Paragraph 7.
Wait.
43. It is very categorically summarized, my lord, in Vijay Lakshmi Sharma case of the KVS, and she is getting pension.
What is laid down in this judgment?
In this, therefore, I am submitting it short, my lord. The Delhi High Court.
How?
Yes.
This is different from the cases which the division bench has considered.
Yes. Therefore, I am submitting, my lord. The learned single judge first heard the matter of Delhi University, same issue, same autonomous body, funded by the central government, my lord. Single judge has categorized three batch of cases, R.N. Virmani batch of cases. They were those who have never exercised the option to continue under CPF as per the circular 1/5/1987, in which cutoff date was 30th/9/1987. Those who have not exercised.
Slowly.
Yes. R.N. Virmani batch of case.
30 years.
Those who have not exercised any option till 30th/9/1987.
who had not exercised.
No, petitioner number 1 to 4 never exercised the option. It is only the presumption of the learned Central Administrative Tribunal that they have exercised the option based on the Jaspal Kaur judgment, which is an old judgment. Now, latest judgment is the Shashi Kiran judgment, my lord. And the second batch of cases is NC Baxi batch of cases. In NC Baxi case of batch of cases, my lord, those who have exercised the option after 30th 9/19 come in this category, NC Baxi. And in Shashi Kiran batch of cases, those who have positively exercised the option in Shashi Kiran batch of cases.
Be kind to us.
No.
Otherwise, we will be unkind to you.
No.
3997 is a class of people who had not exercised the option.
No.
Then the second category is who exercised the option, but after 37/1997.
Yeah,
1997. Huh?
87. Now, that is the cut-off date.
Cut-off date, as per the central government memorandum.
So NC Baxi group exercised their
After
option,
30 September 87.
Yes, ma'am. Yes. And R.N. Virmani is very clear, my lord. Those who have never exercised, they were directed, it was the clause in the 87 circular. Those who never exercised to continue under CPF, their case would be automatically be converted to CPF scheme. That has not been done by the authorities of the KVS. Therefore, they continued under CPF and retired under CPF. That's why in the Shashi Kiran judgment, it has been held even by the Supreme Court, my lord, that in R.N. Virmani, there is no any question of deciding anything because University of Delhi has not challenged that part. They accepted because it was very clear their conversion was automatic as per the circular. That is R.N. Virmani. And NC Baxi was those who have exercised the option after 30th in 1987, and they have also been accepted by the university, by the single judge, thereafter the division bench, thereafter the Supreme Court. That their exercise of option is not tenable, and they have also been given the benefit of pension scheme. Two categories are very clear, and third category was those employees who have exercised positively to continue under CPF. Those who exercise in writing
before 39.
Yes, 30th 9/1987. Those who have positively exercised the option in writing that I will continue CPF, they were in CPF, they presumed themselves to be CPF, and they continued till the retirement. Therefore, issue went up to division bench. Division bench said, no, when NC Baxi case, batch of cases have been allowed by the single judge, in which it has been accepted that after cut off the date, nobody can be, there is no any restriction of availing the option. Meaning thereby there was no any option.
Your case is of non-exercise of option.
Non-exercise of 1 to 4.
Third category.
No, first category. R.N.
No, I am categories you mentioned.
Well,
first category is those who had exercised the option.
No, first category is who didn't exercise the option.
Not exercise the option.
Yes, that is R.N. Virmani.
So they will automatically
conversion. Automatic conversion. CPF. Yes, to GPF. From CPF to GPF compensation. I have annexed the circular also in my annexure 4, my lord, may see.
The case which the bench decided,
yes,
it case related to, is it a non-exercise of option, automatic conversion?
No, Usha Rajgopalan has not exercised the option, but that case has also not been considered, and their case has been rejected on the ground of laches and presumption of the learned single judge that she has, yes, some Madam Mohanty is there, she has exercised the option. That was a wrong presumption of the learned cat in the judgment placed by my learned friend. Usha Rajgopalan is a very old law. Therefore, I want to show the case, my lord. That is annexure 7, page number 59. It will clarify, my lord, everything. Page 59, my lord, may come 59. Paragraph 9 to 12, I want to read before your lordship. Paragraph 9 to 12 only. May I read, my lord? Paragraph 9?
9.
Yes, at page number 69 of my read. While dealing with aspect of switchover in all the three distinct type of eventualities as noted above, the Honorable Apex Court held that the switchover from CPF scheme to the GPF shall be permissible, and the claims of the employees shall not be barred by doctrine of delay and laches and or limitation, in light of fact that the schemes as put in operation approved for the welfare of the employees. In essence, the very choice to select a scheme is deemed and or form part of a beneficial piece of legislation, thereby permitting switch over between two schemes. Therefore, as per the dictum as enunciated in Shashi Kiran Supra, it has been categorically held that switch over shall be permissible to the following three eventualities. First, wherein the employee had not exercised any option at all. Second, wherein the employees had not exercised their option by the cutoff date. And third is, wherein the employees had exercised the positive option by the cutoff date, but were eventually demanding a change in connection therewith. The rationale for permitting switch over in the state eventuality. Sorry.
Your case fits into number 1.
Number 1, four employees. Petitioner number 1 to 4.
Your case is number 1.
Number 1, for my petitioner number 1 to 4. 16, serial 16 contains 5 cases, my lord.
There are 5.
5 writ applications are there.
4 are covered under 1.
1 to 4 are covered under 1. As per the facts of the case. And
this judgment is by whom?
It is by Rajasthan High Court, affirmed up to Supreme Court. They are getting pension. They are also from the same organization, Kendriya Vidyalaya Sangathan. I have annexed also the Supreme Court judgment of the Vijay Lakshmi Sharma case, my lord, after this annexure 8.
This is not referred to by the division?
Yes,
Not at all.
Just in this present case referred as running page 85 the writ petition kindly glance already discussed and disclosed with the Sasikaran case.
Then it is all.
That is please. This court is asking question to me, please. Para 20, running page 85, you lordship got it. Distinguished of the Sasikaran case and discussed. That was placed also in the judgment of the Vaijanti Manti, the judgment given to your lordship. And he has set all the judgment.
We have asked one simple question.
85.
Whether it is a cow or a bullock.
85.
You take
running page it 85, para 20.
He wants us to take us to the veterinary department itself.
Page 20. 85, running page 85, para 20, your lordship. Got it? Of the writ petition. The present writ petition case.
Contemporaneous to your statement, he was.
Sandharani Mahanti.
One second. What he says is,
my lord,
3 classes of employees.
My lord.
Those who do not exercise any option at all.
That
no, he's saying he may be wrong.
My lord.
But we should be heard in the matter.
My lord.
Those who do not exercise option at all. One category. Those who exercise option on or before 30 September 1987. And those who exercise option subsequently. Is it the third category?
No, that's not. Those who exercise positively to continue under CPF are the third category.
It will not arise at all.
Yes.
For them, if everything is in very...
Then I'm not clear to place my case, my lord. First category...
Exercise option. Debtor wanted to change.
Yes.
From CPF to GPF.
GPF.
Yes. Those cases, they cannot get the relief.
No, all have given the relief by the Supreme Court or by the different high courts, and they are getting pension of the same organization. On the ground of differentiation.
My lord, kindly have a glance the judgment order passed by the tribunal where Sasikana case already discussed.
This is the error. They have not considered. They have not considered.
They are running back to 85.
No, you cited...
That is not applicable at all because body. KBS is the autonomous body and that cutoff date is not applicable to the KBS.
Why can't you... What is communication? Communication is catering to the need of the addressee. Correct? We are the addressee because you are addressing us. We want certain things. If you cater to that, you may get order. If you do not get it, certainly you will not get the order. Now, you have cited the Vaijayanti Mohan. In this case, the decision which he has relied upon, is it discussed here?
That copy, way copy and order copy of the way and the Vaijayanti.
No, that we don't see. Whether discussion has taken place in the judgment.
In the judgment, not this.
Yes.
But they have taken into consideration. Because that was discussed in the order of the tribunal. That is within the knowledge of the bench.
Whether we will ask the judge to file affidavit before us?
Then my law.
Whether it is discussed or not, it should be from the judgment. Simple.
Now,
it is not there.
Now, the running page 85 of the read.
They will not dismiss the petition on this ground.
That's
because it has not considered the other argument which he wants to put forth.
That 85.
Yes.
Got it.
Then we have to ask this Sangam sir to come and by the affidavit before us whether it was argued or not.
Yeah. 85. Read petition running page 85. You got it. May I read?
Yeah, 1 second. We'll come back to you. Brother, you were showing in Shashikaran 2022-15 SSC 325.
Yes.
Paragraph 20, running page 85, we were reading something.
Well,
is it not? Just now you are read, no?
I read, my lord, in the Shashikaran, paragraph 7. That contains all the 3 batch of cases. And thereafter I read the Vijay Lakshmi Sharma case, annexure 7, from paragraph 9, and also want to read subsequent paragraphs also.
May I read?
1 second, 1 second. Paragraph 22.
Paragraph 20, starting from 2.
No, he was reading which paragraph?
I was reading in Shashikaran or in Vijay Lakshmi Sharma.
Whichever you were reading.
I was reading lastly in Vijay Lakshmi Sharma, page number, my lord, 69. Paragraph 9 I read. Thereafter I want to read paragraph 10 and up to 12. May I read the paragraph 10? Therefore.
Wait. 69.
9 I've read, page number 69. Thereafter, in all the 3 batch of cases, Supreme Court allows the conversion. Therefore, it can be said.
My lord, the Shashikaran case, which he has annexed, that is the paragraph totally not correct with the reported judgment. I have downloaded reported judgment of the Shashikaran, exact reported judgment, and kindly have a glance. That was recorded in by the tribunal in para 20. That is mismatching the paragraph.
I have annexed the Supreme Court.
My lord, that is second copy. I have handed over one copy. My copy have handed.
I have annexed the SSC online judgment, my lord. Paragraph may be different, but same content is there.
Whether content is the
same.
Last content was the recorded that paragraph. That is the
paragraph may be changed.
That is
only paraphrasing is different.
That is the last. He has placed the discussion, the last, the final.
No, on your argument that divorce is a case where you have not exercised option at all. Correct.
Yes, first 4 cases.
We are asking. First 4, except 5. First 4. They did not exercise any option. If that is so, what the tribunal said on this argument?
Tribunal has decided, my lord, on the basis of Jaspal Kaur judgment that I wanted to show in this paragraph 10 to 12, my lord. Jaspal Kaur judgment says, my lord, that if you have exercised the option, not exercised, not. If you exercise the option, then you were aware about the everything. Plus, Jaspal Kaur says, my lord, if deductions were made from your CPF and you the IT return, then you were well aware. It was of the 2007 judgment. You were well aware. Therefore, it will be presumed that you have positively exercised the option.
1 second.
And that has been overruled by the Shashikaran. Yes. No, not overruled, but judgment says which one is the latest one. Therefore, I want to read 10 to 12. Let me read the 10 to 12 from paragraph, page number 69 onwards. Page number 69. Page number 69 of 9 I have read. All the three categories of cases will get the benefit of pension scheme. Thereafter, paragraph 10. Therefore, last two lines of page number 69. Therefore, it can be said that even the employees who had originally opted to remain in the CPF scheme and subsequently sought to switch over to the pension scheme on account of latter being more beneficial to them was permissible specifically due to the fact that grant of better and or more lucrative benefits by way of pension and denying the same to one set of employees would be per se be discriminatory, notwithstanding the option exercised by the employees to remain in the CPF scheme. Para 11. In this regard, reliance can also be placed upon the judgment of the division bench of the Jharkhand High Court in the matter of Union of India versus Priya Bharat Singh reported in such and such. In the said judgment, while dealing with two distinct viewpoints as expressed by the Honorable Apex Court in Jaspal Kaur Supra and Shashi Kiran Supra, it was held that para 42 of that.
The CAT judgment, which you are reading now.
I am reading
Rajasthan judgment.
Paragraph 11 of Vijay Lakshmi Sharma judgment.
That is case, which court decided it?
Jharkhand High Court. May I refer the judgment also? I have the copy of Priya Bharat Singh judgment also.
No, but
in nutshell, it has been quoted here.
No, sir, this is High Court of Judicature for Rajasthan Bench, Jaipur. You are reading that.
CAT bench it is.
In that very judgment,
it is quoted.
It is quoted in paragraph 11. Page number 70, my lord, of my writ application.
First, let us see which judgment we are reading.
We are reading the Vijay Lakshmi Sharma judgment of Rajasthan High Court in which
the CAT judgment. CAT judgment. Central Administrative Tribunals.
No, I am reading Vijay Lakshmi Sharma judgment of Rajasthan High Court, which held that all the three batch of cases will get the pension.
Page number
70, my lord. Paragraph 11 onwards. I want to only read 11 and 12. That's all. Page 70, my lord. Paragraph 11.
This judgment gave relief to the class of employees who were similarly
situated, all the three categories.
They are asking yes, sir. Yes. Then this was carried to the Apex Court.
My lord.
And what Apex Court said?
Apex Court held it. Correct. I have annexed the judgment of the court at page number 73. Annexure 8.
In this judgment, you wanted to read paragraph
11, my lord.
11.
Which says latest judgment will be followed in the case of conflict between two Supreme Court judgments. The court is having two views of the Honorable Apex Court. One in the case of KBS versus Jaspal Kaur and another in the case of University of Delhi versus Shashi Kiran Supra. The position of law is well settled that if there are two conflicting views of the Honorable Apex Court,
the next latest should be followed.
Yes.
Yes. Go to the next point.
Paragraph 12 says, my lord, therefore, by placing reliance upon the dictum of the Honorable Apex Court enunciated in Shashi Kiran as followed by the division bench of the Jharkhand High Court in Priya Bharat Singh and also conceding the areas to select a scheme esteemed and or form part of beneficial piece of legislation, thereby permitting switch over from CPF to GPF scheme in all three different types of eventualities as discussed above. We are in agreement with the view given by the learned Central Administrative Tribunal, Jaipur, who has taken consideration of all these cases, my lord. Therefore, a writ filed by the Kendriya Vidyalaya Sangathan, Commissioner Kendriya Vidyalaya Sangathan was dismissed and view of the CAT was allowed. In the case of Vijay Lakshmi Sharma, and thereafter several judgments have come, my lord. Several persons of the are getting pension. She is also getting pension.
This matter was taken to the Apex Court.
Yes.
Tell me, where is that judgment of?
My lord, it is annexure 8, page number 73. Annexure 8, page number 73. It is short judgment, my lord. The detailed judgment is not there. It has only been
Dismissed.
This type of judgments are passed by the Honorable Apex Court, my lord, in the case of under Article 136.
My lord, he has also today filed recent judgment of the Apex Court dated 29/11/24.
Not filed, I have only served.
29/11/24 just handed over a judgment copy where the Apex Court allowing they stated that the special person is accordingly dismissed. However, the question of law, if any, is kept open. That is, and the Sasran case totally different, not applicable to KVS. How?
The question is not there. Now one High Court has taken the view.
My lord. But
there is a yes. You say, if you permit us, we will say something. Otherwise, you say yours, whatever we want to do. They are all, this Kendriya Sangatana is a registered society. Correct? It runs all these schools and institutions. Correct? The service conditions of all these teachers is same throughout the country. You agree or not? You agree? You don't agree? No. No use. You need not address the plot at all.
KVS rules and regulations applicable to all over the
uniformity is there. One principle is you can't place one set of employees in a disadvantage for another set when they are working under the same employer. If they are working under the same employer, same designation, same pay scale, they constitute one homogeneous. There cannot be class within the class, subject to exceptions. But it is not a case of exception. Now, the Rajasthan High Court has taken the view that all these people are entitled to benefit. And it has granted benefit. You have implemented, and you challenged it before the Apex Court and last time. You have implemented it for Rajasthan people. Why can't you implement it to Orissa people?
Now, my lord, in this case, this case totally different than Rajasthan KBS employees case.
Why?
Because we have filed here the secondary documents which are taken by the tribunal and filed here before leadership through counter. They have given their option form to continue CPF till retirement and revised number was given. The document I am showing the through counter.
So it is a case of exercise of option.
Exercise of option.
They have exercised the option.
Our case is all the documents provided that they have exercised within the cut-off that is 89. He has stated that 87 of the for the government of India. Autonomous body, he has annexed the document. That is the Board of Governors decided to adopt the government of India's decision on 88. And he has annexed the document.
So having exercised the option, later they wanted to shift from CPF to GPF.
CPF to GPF, and they have given the option to continue from CPF to CPF. They have given the option to continue from CPF to CPF. They have already given the option. Therefore, they have got the revised CPF number, and they have continued.
Where is that?
That is. Kindly have a glance. My lord, my counter, and he has given the option form C for change of nominee. That is kindly have a glance, my lord.
Is it true?
My lord. Yes,
not true.
Yes.
Documents are true, but it is not the exercise of
not challenged before the tribunal.
It is not the exercise of option as per 1987 or 88 circular.
77, my lord. Running page.
My lord, it's been showing only
yes. Running page 71 to counter. This is Central School Employees Contributory Provident Fund Form B. Running page 77 of my counter. The employee concerned, the present employee, in the presence of two witnesses on 13/1/2015, has given the nominee of Maitri Mahanti 100% nominee. That is prior to retirement. She has retired on 31st January 2015. Prior to retirement, knowing fully well, has continued as a CPF contributory fund.
Form B.
Form B for nominee. Change of nominee. She has changed her nominee 100% to her daughter. She has filed with the two witnesses, present of two witnesses of the Kevista. That is her within her knowledge. She is continuing since 18 and date of notification, that is 31st January 1989 till her retirement 31st January 2015. She was continuing under revised CPF number. That is revised CPF number, and then next page 78. Next page 78, my lord, last person. It is therefore requested that necessary correction, that is dated 3rd 889. On the 89, she has already account number, her CPF account number 1814 bracket old number 3527. She has got a new number on 23rd 889, that is between the cut-off date. She has already revised number got and CPS, then next page contribution, last pay scale, where mentioned the new CPF account number 1814. Each and every month CPF contribution that is deducted from her salary within her knowledge. And she retired with all the CPF benefits and enjoyed till 2001. In the year of 2001, she challenged before the tribunal after 6 years of retirement, when she got one order of the other. That is, she admitted in her representation in the way, she admitting that in her representation that I have continued under CPF, but I came to know, therefore I have filed this case. I came to know it is not out of place to mention. This is the representation annexure 2 series running page 22 of the writ petition. It is not out of place to mention here that I had represented for change of CPF to GPF several times after 1186. Once after 1186, you have given representation, you have not acknowledged, not a receipt, not a proof given before the authority or tribunal. The last occasion, therefore, you will ask the question, you are a senior teacher. That is the Jaspal Kaur case. 3 pages judgment I have annexed in this counter. 3 pages judgment of Jaspal Kaur case squarely covered to the present case. You are a senior teacher, you are a class 2 officer, you are not a illiterate person. You law the rules and regulations, you have continued the CPF till the retirement. After retirement after 6 years, you have enjoyed all the benefits. Now you are compared with your benefits, which is the better for you. Therefore, you came to the court. And after 8 months, you are challenged before your lordship. And last one, my lord, he has committed fraud with the tribunal. He has filed the option form 30th 189 in the presence of principal. But he has filed the case. No, I have not filed any option form to change it. When I have submitted the document with the counterfeit, court passed a separate order in the last item Chaitanya Pradhan case with a heavy word that you have committed fraud with the court. You are a teacher. You are a teaching novel in the novel profession. You are filed you only to grab the public with the taxpayers' money. You are now enjoying the money, and now you are compare the money, the better money. Therefore, that option form is there in the last case. Therefore, he has committed fraud with the court. Obliged.
May I submit, my lord, in reply, my lord? What my learned friend has argued now, and so
1 minute, and the subsequent case, 14 times opportunity was given to the that I have folded, my lord. That judgment I have handed over, folded with marker. 14 times opportunity given by the NCT, and the NCT case is not uploaded to KBS, because the NCT Just given any opportunity to the any employees.
May I submit my reply, my lord?
Obliged.
What documents my learned friend has showed now, the
Not now.
CPF nominee.
I have not given a single new document before my lord.
Yes,
Already
let me submit the reply. What my learned friend has document shows, all are secondary evidence, and my learned friend has also stated that it is based on Jaspal Kaur. Yes, it is true, my lord, that in the case of Jaspal Kaur, these secondary evidence were considered. But now latest judgment is the Shashi Kiran case, and on the basis of Shashi Kiran case, all the 3 batch of cases have been directed to be converted to CPF to GPF cum pension scheme. Therefore, as per my submission, my lord, Shashi Kiran case has to be followed as followed by the Rajasthan High Court. And my lord, for the last writ application of Mr. Chaitanya Pradhan is the writ petitioner. I have brought this through judgment of Madhya Pradesh High Court. In this case, my lord, he has also exercised the option on 16/1/1989 as per 88 circular issued by last cutoff date was 31st January 1989, and he had exercised the option on 16/1/1989, and my client, the petitioner number in the 5th writ, my lord, he had exercised the option on 30th/1/1989. Therefore, as per this judgment, it has also been affirmed up to Supreme Court, and given the interest also and getting the pension, my lord, it has been held, my lord, that of exercise of option after cutoff date of 30th/7/1987 are null and void. Null and void.
But it has fixed by the KBS under Annexure 5.
No. Several recent judgments
that
have come.
cutoff date is not a union of India cutoff date is not a cutoff date. KBS had fixed the cutoff date that is the 31st/1/1989.
He is also from KBS. Mr. Ram there.
Therefore, he has filed.
Item 65. Now, what is the matter of what is the urgency?
Recruitment matter.